Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and MICHAEL's ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
What a day it is, huh? What a day. You've been served. They've been served. They've been served. We got the papers. We're going to read them. They're 46 pages long. Had to eat a spoonful of Manuka honey, try and make myself feel a little bit better than I did this morning. And, this is, we've been waiting for this. What a time to be alive, says Kate. What a time to be alive. It's a beautiful day. I put it up on my Instagram and I said, what song should I use today? And so I put it to Led Zeppelin's Your Time Is Gonna Come. Sing along with me. Why don't you? Your time is gonna come. And you know what's so interesting about this lawsuit, too, that was filed by Karen Reed against just about everyone except for the municipal defendants, because she can't sue them just yet. Is that this is not in any way connected to the case that's already pending in Plymouth County. No. This is an entirely new lawsuit in Bristol County. So Karen Reed has filed a 46-page lawsuit in Bristol County against everyone. We got the let out. Sometimes you're just not feeling up to it. You just got to get up, put some clothes on, put some makeup on. This morning, I literally rolled that about and threw it on Facebook app, and you can probably tell. You just got to power through because it's a beautiful day, as U2 would say. And you know what? That's interesting too, because U2 is Karen Reed's favorite band. It is. Have you seen any ice cream trucks around Canton today? And doesn't it make complete sense now why yesterday the McCABEs and Alberts and Brian Higgins, made that press release or whatever they did about how they intend on maybe filing a defamation suit against Karen Reed? Okay. Go on with your bad selves if you want to. But somebody also sent me that Alan Jackson had a statement, and now I just can't find it, and I don't know who sent it to me. And so it's lost somewhere in my inbox of 7,000 emails from this morning. But hold on, because I think I can find it maybe somewhere. Ted Daniel, I think, put up a statement from Alan Jackson. You want to hear that first? Let's do that first, shall we? All right. I can't imagine how many Twitiots were freaking out this morning when Twitter was down because it was part of the Cloudflare outage, and Canva was even down and some other things too that I'm not familiar with. The only thing it affected me with is Canva. But Ted Daniel tweeted this just a little while ago, and it is Alan Jackson's statement from Karen Reed's civil team and written, I guess, by Alan Jackson to Ted Daniel, who was really the only friendly reporter in the Massachusetts area that covered the Karen Reed trial and case at all. He's the only one who could see the corruption, is Ted Daniel. So shout out to Ted Daniel for getting it right for getting it right, because John O'Keefe was not hit by a car. A car did not hit John O'Keefe, and therefore something else happened to him. Someone else murdered him. Maybe it was an accident, and maybe the crime was in the cover-up. We don't know. But John O'Keefe was not hit by a car, according to all the medical experts, all the accident reconstructionists, and I could see that from a mile away because, over 30 years experience in civil litigation myself, having handled thousands and thousands of car accidents, I knew that those injuries did not coincide with a pedestrian versus motor vehicle accident. They just didn't. So here we are. Maybe this is the day of reckoning. And here's what Alan Jackson has to say about it. Ted Daniel tweeted just moments ago, not moments ago, a while ago, when we were on the other stream with Brian Walsh, where he pleaded guilty to 2 of his 3 charges, but we're still going to trial on the murder, so don't worry. Ted Daniel says, I reached out to the lawyers for the McCABEs, Alberts, and O'Keefes, and Brian Higgins about Karen Reed's new lawsuit and their proposed claim against her. I'll let you know if I hear back. This just released statement is from Alan Jackson and Karen Reed's civil team. Quote, today's filing speaks for itself. It is a meticulously documented civil action grounded in evidence, law, and the Constitution. For more than 3 years, Karen Reed was dragged through a baseless criminal prosecution engineered by individuals who abused their authority, manipulated the investigative process, and trampled her rights. Our complaint lays out in stark detail the malicious prosecution, the conspiracy, the civil rights violations, and the intentional misconduct that these defendants visited upon an innocent woman. If these defendants want to answer for that under oath, we welcome it. What we will not do is legitimize a threat to file some imaginary, quote, defamation case. That threat is nothing more than a desperate attempt by these defendants to distract the public from the very real legal jeopardy they now face. When people start waving around defamation claims to mask their own legal troubles, it tells you everything you need to know. They don't want sunlight, they want silence. Karen Reed spent years fighting for her freedom against a corrupted investigation. Now she is fighting for accountability. And unlike the criminal case, this time the defendants don't get to hide behind badges, back-channel favors, or manufactured narratives. They will have to answer in a court of law for every lie, every omission, every manipulated report, and every constitutional violation they committed. Karen Reed is not backing down. Our team is not backing down. Accountability is coming, and these defendants can threaten all the phantom lawsuits they want, but the truth doesn't flinch. The truth doesn't flinch. And this is from Alan Jackson, or actually Ted Daniel tweeted this at 11:35, about 1 hour ago. And that is a statement from Karen Reed's civil team, including Alan Jackson. All right. Hold on 1 second, because I'm not the only one sick in this house. So 1 moment. If I have to leave you for a moment to take a call from a school or a child, please forgive me. All right, moving on. 1 moment. Hold, please. Come on. Oh, this new iPhone update is really screwing with me. Anybody else? We'll get used to it eventually. I don't know what this glass thing is. It's like George Glass. That's so funny because, the Brady Bunch is on certain channels all the time. And the other day I turned it on and it was the episode about George Glass and Jan. And so, okay, let's do it. Let's do it. Mom's got a mom. Mom's got a mom in the middle and between all of the other things that we do. Okay. All right, let's get to it, shall we? This is a brand spanking new lawsuit in Bristol County. It has nothing to do with the lawsuit currently pending against Karen Reed, which is in Plymouth County by the O'Keefes against Karen Reed and the Waterfall and CF McCarthy's. And my opinion is, I'll give you my opinion now before you even ask for it. My opinion is that Karen's civil team saw the writing on the wall with that last conference with Judge Daniel O'Shea, in which the judge was kind of like, yeah, I don't think I'm going to let you do that. I don't think I'm going to let you third party in 10 new defendants here. And so you're going to have to make a motion and do the abada, and then they'll fight it. And so they said, you know what, F it. We're just going to file a different lawsuit in Bristol County. And we're just going to do it that way. And maybe eventually they'll be consolidated, maybe not. But procedurally, this is the easiest way to do it without having to ask permission. And so that's what they did. It was filed yesterday, November 17th, 2025 in Bristol County. And so why not just start a brand new lawsuit, brand spanking new? All right, here we go. Filed yesterday in Bristol County. And then I just noticed also, there's been no answers filed, okay? So what we thought was happening, here's what I thought was happening. Damon Seligson, remember, he went on Howie Carr one day and we played the piece on Howie Carr, and he told Howie Carr that the filing of this civil rights lawsuit was going to be imminent. And so I thought, and I think maybe we all thought, that they were going to file it under the same case number in Plymouth, and they were going to make a motion to third party in all these defendants and say that, you know, it's common issues of law and fact, and in order for us to have judicial economy, it's better if we bring this all in one lawsuit. And so I kept checking the docket on the Plymouth case. The Plymouth case, and what happens when you file a motion like that in Massachusetts, it's unusual because a lot of other states don't do it this way. Cosgrove's reverse mortgage said, George Glass whacked Anna Walsh. Okay. May Anna Walsh rest in peace and God rest her soul. Okay. In Massachusetts, when you file a motion such as like that, it does not hit the docket until the responsive pleadings are in. So you file the motion, the defendants file their response, maybe you file a reply, and then everything gets docketed all at the same time. And so it wouldn't hit the docket and become public information until such time as all the papers are in. This is different. This is a complaint in a different county. And so it is the only thing right now that has been filed in this lawsuit. And so there are no answers. The answers have not been filed. So whatever it is that the defendant's attorneys said, and here I have this as well. This is very interesting to me. I don't believe that was from a responsive pleading because no answer or answers have hit the docket yet. But what I do see here is a civil action cover sheet. So let me just see what this is here. Well, this is in Karen Reed's case. And it looks like somebody is accepting service. And it seems to be the same lawyer accepting service for all the defendants. So I'm not really quite sure what this means, but I'm going to put it up on I'm going to put this up first anyway, so you can just take a look at it. So let me just put this up first. This is the civil action cover sheet that is attached to the lawsuit. And I can't imagine that all of these defendants are going to have the same lawyer, because that would just be malpractice on any lawyer's part, because they all have differing interests, and that would not be appropriate, in my opinion. But this civil action cover sheet, there's probably going to be some questions about this, and I have questions about this too. This was just sent to me, so let's take a look. Oh, well, it's tiny. Can we make it bigger? This was filed with the lawsuit. So this was filed by Karen's attorneys. And it's got the defendants all listed here. And it's got their addresses listed as an attorney's address, James Tuxbury of Hinckley Allen, 28 State Street in Boston. Maybe this attorney reached out and said, listen, you don't need to serve the defendants. You can serve us instead. But I can't imagine that this James Tuxbury is going to be representing all of these defendants, because that would just be malpractice waiting to happen. Brian Tully, it looks like, is represented by someone, or at least they're accepting service, Timothy Burke, Esquire, Law Office of Timothy Burke in Needham. And then YURY Bukhenik and MICHAEL Proctor, looks like they were served somewhere else. So that is a publicly filed document. It is the civil cover sheet to this lawsuit. All right, moving on. They have not filed their answers yet. So I was mistaken when I thought, when someone sent that to me, that that's what it was. It is not. All right. So here we go. Here's the lawsuit we've all been waiting for. Settle in, get your popcorn, and here we go. Make this scooch bigger for you. And this is filed in Bristol Superior Court. The defendants are, this is entitled Karen Reed versus Michael Proctor in his personal capacity. That means not as an employee of the Massachusetts State Police. Sergeant YURY Bukhenik in his personal capacity. Lieutenant Brian Tully in his personal capacity. That means not as an employee of the Massachusetts State Police, but personally. And when you're sued personally, you have to get your own personal attorney to represent you. You cannot use the attorney for the Massachusetts State Police. And as you see, they are going to be brought into this case, but there are some procedural hoops that need to be jumped through before they can bring in the town and the county. Hold on one second. Brian Albert, Nicole Albert, Jennifer McCABE, Matthew McCabe, and Brian Higgins. Dun, dun, dun. Complaint. And there's a footnote already right after the word complaint. And the footnote says the Massachusetts State Police and the town of Canton will be added as defendants after presentment is made pursuant to General Law 258, Section 4. And what that means is you cannot sue a municipality until you jump through some procedural hoops. And in Massachusetts, you have to serve them with a letter of intent that you are going to sue them. And then they have to, I think, deny it in writing. There are certain procedural hoops that have to be jumped through. They haven't done that yet, so they can't add them as defendants until such time as they present the claim, and the claim must be denied, and then they can bring them in as defendants, which they will do, as they are telling us right here in footnote 2. Introduction. I'm going to have to take frequent breaks to hydrate my throat because, as I told you earlier today, I'm not feeling great, but we're powering through because that's what we do here. We power through. All right. Introduction. For 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police, MSP, and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. Finally, he's getting his title. Boston police officer John O'Keefe III. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those. All right, where was footnote 2? Did I miss footnote 2? Oh, footnote 1. I'm sorry. Footnote 1 was after defendants, and that's where it says that they intend to sue the town of Canton and Massachusetts State Police after they jump through the procedural hoops. And then footnote 2, after complaint, says plaintiff intends to move to consolidate this action with the related action as stated John O'Keefe versus Reed et al. Civil action for discovery and trial efficiencies. Well, that's interesting because that case is pending in a different county. So I don't really know how that's going to work. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29th, 2022. Suing them personally may also be a way to get around qualified immunity because I'm sure she's going to allege, I haven't read this yet, it's a cold read, that they were acting with outside the scope of their employment with the Massachusetts State Police, the 3 that she named personally, to wit, Proctor, Bukhenik, and Tully. Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed in defendants Brian and Nicole Albert's home at 34 Fairview Road in Canton. house. In an altercation during a late night house party with other defendants, collectively the House defendants, after a night of heavy drinking. Well, let's just get straight to the point, shall we? The House defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Read. Rather than call first responders for help, among other actions, the House defendants conducted a Google search for information about Haas long to die in cold, moved Mr. O'Keefe's body outside and placed him on the Alberts' front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained in the Alberts' lawn, on the Alberts' lawn, until Karen Read found him later in the morning. Well, there are no words being minced here. They're laying out exactly what they think happened. That's their theory of the case. Are you ready for it? And they've got to prove it. So let's assume that they've got evidence to prove it. From the beginning, investigators from the MSP allowed the House defendants to direct the investigation away from themselves and towards Ms. Read. The House defendants were a well-connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigating police officers knew them well. The lead investigator for MSP, MICHAEL PROCTOR, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family. House defendant Brian Albert was a longtime Boston police officer, and House defendant Brian Higgins was an agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. You know, it's interesting. Prominent family. I was watching somebody's testimony the other day. Was it Proctor's? And Alan Jackson was hammering him on whether or not he thought the Alberts were a prominent family. And he was like, well, you know, it depends on your definition of prominent. You can correct me if I'm wrong, but I think it was MICHAEL PROCTOR who testified to that. Either that or Brian Albert, because I watched both of their testimonies the other day. Adhering to the unwritten rule of protecting their own, Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash to the back of his head, suggesting that he was punched and fell backwards, hitting his head on a ridged surface. He also had dog bite wounds and scratches on his right arm and forearm. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact from a 3-ton vehicle. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike. That's right. Irene Scortibello testified to that. Dr. Irene Scortibello testified she looked for injuries consistent with a motor vehicle accident, and she did not find them. Thank you. Friend of Dog gifted 10 memberships. You are so amazing. And Tony76 gifted 5 memberships. Welcome to the 15 new members. You guys are super, super kind and generous. And I thank you so very much with all of my heart. Most Blessed Gigi also gifted 5 memberships. Thank you so very much. So if everyone could just smash the like button right now, that'd be amazing. Friend or dog gifted 10. Tony gifted 5. I'm going to get to the super chats at places where I'm going to break during the stream. So don't worry if you don't see your super chat coming up right now. I will not ignore you. I promise you. You will not be ignored. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. Propelled by the House defendants' false statements, including that Mr. O'Keefe, quote, never went into the house, Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any, quote, shit for this because, quote, he's a Boston cop, Brian Albert, and that Proctor was determined to make the investigation cut and dry, end quote, and by bringing, quote, charges against the girl. Indeed, Proctor made his intentions clear in writing. Karen Reed had, quote, zero chance of skating. She's, I'll say effed for those of you listening at work. And if you are listening at work and you have your earbuds in, I hope you get some work today because we're going to be here all day. This pronouncement was a mere 16 hours after Mr. O'Keefe's body was discovered on the Albert's lawn, and Proctor had not even walked into the house. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash to the back of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house, despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminalist or even photographed. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. Remember, the only two who did that morning were Sergeant Sean Good of the Canton PD, who has since been suspended as of right now with pay based on what was found in Proctor's phone extraction, and Lanka. What's his name? Michael Lank, also of Canton PD. So no MSP set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Albert's German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. Neither Proctor nor start again. Well, I meant to mute my mic because misophonia folks get really triggered when I swallow into the mic, so I apologize for that. I thought I muted it, but I didn't. I apologize. Neither Proctor nor any of the MSP troopers conducted physical examinations of the House defendants for evidence of involvement in the altercation, such as marks on their hands, knuckles, or face, or bruises on their bodies. They did not seize or search the House defendants' phones. They conducted only perfunctory, unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. In short, by focusing on the investigation solely on Ms. Reed as implicitly directed by the House defendants through the misrepresentations they made to police, Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. Yeah, until deposition. Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device and use his sister as a conduit. For example, or for instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information to her close friend, Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed that same information on to the rest of her family and the House defendants. Part of these communications included Julie Albert's promise to buy Proctor a thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants and singularly focused on Ms. Reed. So far, we're only on, that was paragraph 8. Everything that has been mentioned so far was already proven during the 2 trials, during the 2 persecutions of Karen Reed, right? It's already been proven. There's receipts on all of this stuff. Proctor then went so far as to manufacture evidence. This is a bold claim. Let's see what they have. Proctor then went so far as to manufacture evidence to ensure that Ms. Reed, not his friends and fellow law enforcement officers, was blamed for Mr. O'Keefe's death. This included planting evidence at the scene on Mr. O'Keefe's clothes and on Ms. Reed's vehicle to support the false narrative that Ms. Reed hit Mr. O'Keefe with her car, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack. Well, that is a bold claim, alleging that he actually planted and manufactured and planted evidence at the scene, meaning 34 Fairview scene, on John O'Keefe's clothing and on Karen's vehicle. They must have receipts. And I want to see them too, craftastical. Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Ms. Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed he would never be discovered exposed the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Ms. Reed is a whack job C-word, the R word, a nutbag, and a babe with no ass. Proctor further ridiculed and derided Ms. Reed for her serious medical conditions, stating that her balloon knot leaked poo. In other private text messages to his MSP supervisors and colleagues, Proctor bragged that while conducting a search of Ms. Reed's phone, he was looking for naked pictures of Ms. Reed. Disappointed, he reported that there were, quote, no nudes so far, end quote. In an unfiltered utterance, Proctor revealed his true mindset. Hopefully, and this is quoted, hopefully she kills herself. The only issue I take with that statement, with that paragraph, is that I think these weren't just high school buddies. I think some of these friends, didn't they go back to like middle school? And there was like something like 35,000 messages or something in their text chain. And boy, we know now that the total phone extraction has been done, which is going to uncover more things than the federal TUI documents and the federal TUI dump, because in the total phone extraction that was just turned over in the Brian Walsh case to all of the defendants, the 19 cases that are still pending, that Proctor was involved in, not only do they have his text messages going back to 2013, but also photographs, voice notes, I don't know if voicemails, but video and emails, not just the text messages, and maybe other messages from, I don't know, Facebook Messenger, Instagram message. I don't know what other messaging apps he used, but they have all of it. And I'm sure that these plaintiffs' attorneys will make a motion to get all that stuff for their case too, if they don't already have it. Indeed, Proctor's supervisors and the MSP knew about and condoned Proctor's unlawful conduct, and in some instances expressly encouraged this flagrant abuse of power. For example, On one occasion, Proctor's immediate supervisor, YURY Bukhenik, responded with a thumbs up emoji to a text calling Ms. Reed the R word. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret of his bias against Ms. Reed, demonstrating a clear prejudice against her from the outset. Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing toward the House defendants, the Commonwealth secured 2 separate arrest warrants for Ms. Reed and a knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only underlie plaintiff's meritless wrongful death claim against Ms. Reed, but they also form the foundation for Ms. Reed's claims against the defendants. These acts violated Ms. Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. Torts was my favorite class in law school, can you tell? On June 18th of 2025, after a 2-month trial, a jury rejected the Commonwealth's theory in part because the overwhelming physical, scientific, and medical evidence established that Ms. Reed's vehicle did not strike Mr. O'Keefe and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Ms. Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Ms. Reed. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, quote, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as Colonel, the state police has and will continue to improve in these regards." In other words, we'll try harder. In an interview with the Boston Herald, Noble acknowledged the systemic nature of MSP's conduct in Ms. Reed's case. Quote, "I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor. These hollow words do nothing to right the devastating wrongs that have been visited on Ms. Reed. Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it." I don't know who wrote this complaint, but I am loving it. I'm loving the choice of words. I am loving the ease in which it flows. I am loving the story that it is telling. I am loving the receipts that are encapsulated within each paragraph, and I'm loving it. It is easy to understand. It is easy to follow. And this is excellent legal writing. So shout out to whoever drafted this. It might have been a group effort. Fantastic job. On Wednesday, March 19th, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the MSP's trial board found Michael Proctor guilty of a Class A violation, which included, quote, that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the Massachusetts State Police into disrepute, end quote. Ms. Reed's life was not merely turned upside down by the MSPs and the House defendants' misconduct. It was forever changed by the defendants' transgressions and wrongdoing. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family has received justice. His killer or killers still walk free. By asserting her claims against MSP, Proctor, his supervisors, the town of Canton, and the House defendants, Ms. Reed seeks, at minimum, to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. Praise be. Praise be. Let's go to the chat for a moment while we relish in the words of the plaintiff's attorney. So many complaints are just cut and paste, change the names, change the dates, change the facts. This is so well drafted that the judge who was assigned to this case is going to know exactly what the theory of the case is by reading only the first 7 pages of this complaint. It's all right there. The House of Disrepute, 34 Fairview. Well done, Anne. Well done. Couple new members. Welcome to Sprinkles, and welcome to Curly Girl and Gigi. I think I thanked you before, but thank you again, Claire. Thanks for becoming a member. I think you're gonna like it here. David Reese says, "I gotta get the papers. The papers. The papers." Jimmy 2 times. Jimmy 2 times from Goodfellas. That's where it comes from. Gotta get the papers. Thanks, David. Cuber says, "Listening on our training jog, Attorney Mel. You're in our ears. Thank you. Justice for Officer Don O'Keefe and full exoneration for Karen Reed. Praise be under her eye." Thank you, Hubert, for being here. I know you're a local, and I know that this is a very difficult case for you and yours. Prayers up for everyone who lives in Norfolk County, including Emily C. Quinley became a member. Oh, no, Quinley's been a member for 2 months. So thank you for hanging out with me for 2 months. Bill has been here for 7 and says, "Adam Deach, the federal prosecutor who investigated the investigation of John O'Keefe, is running for Norfolk County DA, Boston Globe via Nick Rocco." Wow. Wow, what a great day for him to announce his running. Did he just announce it today? Thank you, Bill. Kim Robinson has been here for 6 months and says, "Watching the McAlberts plead the fifth." We'll see. We'll see. Thank you, Kim. They say they want to sue her right back. They say they're coming for her. They say in their statement yesterday by an attorney who was unnamed, they say they're going to sue Karen Reed and Aidan Carney for defamation. And Aidan Carney responded to that with 2 words and more words, but his 2 words were "do it." Gigi says that episode just turned into bankruptcy. Thank you, Gigi, for your super chat. They're opening up the gates, says Truth Doesn't Flinch. 14 months, you're an OG. Thanks for being here so long. Susan gifted 5 memberships. Thank you. On top, thank you for another super sticker today. You're amazing. Fire Pilot's Wife gifted 20 memberships. A lot of new members today. If you're new, we've got lots of emojis from members, including all of the ones that were made for this trial. The solo cups, the what if any, the wait for us, the puffy jacket. My personal favorite today is the handcuffs. So enjoy some Grateful Dead stuff, some Dave Matthews stuff, some Colorado Buff stuff, and everything. Thank you for 20 members. Fire Pilot's Wife, you're amazing. Barbie says, "So happy to be part of this classy group." We try to keep it classy, unlike so many others out there in other places. And so I'm glad that you appreciate it. And Glamasu says, "I will never forget Prosser on torts, ever, ever, ever." Yes, folks, paralegal study case law 2. Yes. Here's another episode for Maddie. Well, it's going to be season 3. It's going to be season 3. And what would it be without breaking news on the Melanie Little Show? Thank you to Kyle Sharkey for sending this right over. Seems that the attorneys for Brian Higgins, Nicole Albert, Brian Albert, and they've made a statement too. And Ted Daniel just tweeted that. So we're not going to miss a damn thing. Hang on. Let's listen to this. Will be a cold read. So let's see what their statement is. Because, of course, they can't let Alan Jackson have the last word. I mean, that would just be so crazy, right? Thank you, Lamasus. I love you so much. Here's their new statement, just tweeted 1 moment ago, thanks to Kyle Sharkey. New statement from the attorneys for Brian Higgins, Nicole Albert, Brian Albert, Jennifer McCabe, and Matthew McCabe. The allegations made by Karen Reed are entirely false, defamatory, and without merit. Our clients categorically deny each and every claim. This lawsuit is nothing more than a continuation of a baseless conspiracy narrative that has caused significant harm to the reputation and lives of innocent people. Our clients acted responsibly, fulfilling their civic duty as witnesses, and have participated appropriately in the legal process from the outset. Ms. Reed's claims distort the facts, misrepresent the evidence, and target private citizens in an attempt to deflect blame. As reported yesterday, we will hold Ms. Reed accountable for the harm she has inflicted and the conspiracy she and Aidan Carney, also known as Turtle Boy, have manufactured. And that only has 306 views because it was only tweeted 1 moment ago. And interesting to me is that no lawyer will attach his or her name to that statement. Why is the lawyer not being named? If you're a lawyer and you're representing these people and you're their spokesperson and you're proud of it, why wouldn't you attach your name to that statement? That's bizarre to me. And somebody, the first comment is Alan Jackson with the chef's kiss statement, Game of Thrones style. Love it. That was somebody named Jen Mary who tweeted underneath that. No doubt. Written by Jenny McCabe, it says. Let me just make sure there's nothing on the next page that needs redaction before I put it up. Okay. All right. We're good on that. All right. Thank you, Glamasuz. And Teresa is here from Ireland. See, the world is watching. The world is watching. It ain't over. It ain't over yet, you guys. We got a lot of more seasons of this show, and it's going to go on for many more years to come. And we're here for it because it does appear that Karen Reed is the only one looking for justice for John O'Keefe, as well as all of you in the chat, except for the haters that are watching. And Aidan Carney and other creators that have been covering this on the right side of things since, well, for me, January of 2024. And the world is watching, and Teresa Nick is here to prove it, and she's been here for a long time. Thank you very much for being here. Catch me if you can, says 18 months and counting. Thank you, Aaron, for becoming a new member. And Monique, 16 months, fantastic day to celebrate 16 months. And Karen Reed, and best rabbit hole ever, says Mads Tea Party. Thanks for your super chat. Queen Olive, new member, welcome. Bernard, welcome. And Dwayne B says, mention it all, mention it all. Thanks for your super chat, sweetie. Songbits Laura says, whoop, whoop. And here we go. And Mia is here from Sweden. The world is watching. All right. Why do they hate justice for John O'Keefe? I don't know. I don't know. Moving on to page 8 of the complaint in the new action filed in Bristol County by Karen Reed. Section Roman 2, parties, footnote 3 says, as stated above, MSP will be added as a new party. I gotta make my screen bigger. By amendment, once the applicable presentment period expires. We got over 10,000 people in the chat. Everyone smash the like button. Tell your friends. We're here. We're doing it. We're doing all the things. We ain't got no quit. We ain't got no quit. And we are outraged. Plaintiff Karen Reed is an individual residing in North Dighton, Massachusetts. Is North Dighton in Bristol County? That you can, one of the bases for jurisdiction or venue is plaintiff's residence. And if North Dighton is in Bristol County, that would explain why she filed in Bristol County. Hold on. Survey says yes. Defendant MICHAEL PROCTOR is a former Massachusetts State Police trooper residing in Canton, Mass. He is being sued in his personal capacity. It's a way to get around qualified immunity. Defendant Sergeant YURIY Bukhenik is a Massachusetts State Police trooper residing in Stoughton, Massachusetts. He is being sued in his personal capacity. Defendant Lieutenant Brian Tully is a Massachusetts State Police trooper residing in Hingham, Mass. He is being sued in his personal capacity. Tully is everywhere. Defendant Brian Albert is an individual residing in Norwood, Massachusetts. Same for Nicole Albert. Jennifer McCabe and Matthew McCabe reside in Canton, Massachusetts. And Brian Higgins resides in Sandwich, Massachusetts. On the Cape, right? Roman 3, jurisdiction and venue. The court has jurisdiction over all claims in this case pursuant to General Law 12, and with regard to the federal claims pursuant to a name that I'm going to butcher, Rezeznik versus Chief of Police, 1978 case in Massachusetts. Venue is appropriate in this court pursuant to General Law 223 because at least one party to this case, plaintiff Karen Reed, resides in Bristol County. See, I was right. And so all I needed to do was read a little bit further. Roman 4, facts common to all counts. Mr. O'Keefe's death. Before his death, Mr. O'Keefe and Ms. Reed were dating. On the evening of January 28th, 2022, Mr. O'Keefe and Ms. Reed went out for the night. They first went to C.F. McCarthy's in Canton, where they had several drinks. They then went to the Waterfall Bar in Canton. There, they met up with a group of acquaintances, including Brian Albert, his wife Nicole Albert, Brian's brother, Chris Albert, his wife Julie, Jennifer McCABE, Nicole's sister and Brian's sister-in-law. Her husband, Matthew McCabe, and Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the Alberts' home in Canton at 34 Fairview Road, the house. House defendant Jennifer McCabe told John O'Keefe that he should come to the house. The group had overlapping social relationships. At the time, Brian Albert was a Boston police officer, as was Mr. O'Keefe, though they did not know each other well. Brian Albert and Brian Higgins were close friends. Higgins was an officer with the ATF. He also was permitted to keep an office at the Canton PD alongside Brian Albert's brother, Canton Police Detective Kevin Albert. Kevin Albert had a professional and social relationship with MICHAEL Proctor. I like how they can connect all the dots and familial ties in literally one sentence. Well done. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s birthday. In addition, Colin Albert, Brian Albert's nephew, was present. Ms. Reed and Mr. O'Keefe have never been to the house. Had never been to the house before January 29th of 2022. They arrived in front of the Alberts' home around 12:20 a.m. Ms. Reed was reluctant to attend the party for several reasons, including that she was unsure whether they were at the correct location and whether they were even welcome to the late night party. Mr. O'Keefe got out of Ms. Reed's SUV and indicated that he would check out the party and report back to her. Mr. O'Keefe walked toward the front door/garage door area of the house and entered one of the two doors. A period of time passed. When they say one of the two doors, I'm not sure if they are talking about, because we know there's 3 doors on the front of the house, right? Jennifer McCabe seemed really, really surprised by that. She seemed really surprised, like, oh yeah, that door goes to the garage. Oh wow, yeah. Meanwhile, she's known Brian Albert since she was 6. And Brian Albert grew up in that house. But she was very surprised to learn that on the little breezeway there to the side of 34 Fairview, not only was there a door that went into the house, I think it went into the family room, but there was also a door that went into the garage. And then towards the left of the home, kind of it's like a center hall colonial, there is a center front door where Coco said there was a bench to take your shoes off inside that door. So I'm not sure if they're referring to, when they say front door garage area, I think they mean the front door where there's the garage door opening that you can pull your car into, and then another door that you can go into the garage as a human. Dude, where's my garage? Well done. A period of time passed without any word from Mr. O'Keefe. Ms. Reed, who was still hesitant to join, presumed that Mr. O'Keefe intended to stay, and therefore she left to go home without him. And now we're hearing Karen's parts of the stories that maybe she didn't tell in the interviews that she gave on all of the Dateline, Nightline, Vanity Fair, etc. Hold, please. At some point after entering the house/garage, Mr. O'Keefe was involved in a physical altercation either inside the house or garage. During that altercation, the Albert's German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating contre-coup wound on the back of his head. Mr. O'Keefe's head wound was caused by falling backwards and striking a ridged surface, like a step. The Albert's garage contains such surfaces. By contrast, the head wound could not have been caused by a vehicle strike or falling backwards onto a flat, cold lawn like the Alberts, even though they tried to convince you, me, the world, and everyone that the rock-hard ground would have split his head open. Remember the weatherman? What a great witness he was for the defense. Because of their knowledge of criminal investigations, the Alberts, the McCABEs, and Higgins, House defendants, knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate and irreversible risk of their own criminal exposure. Therefore, at least the 5 of them agreed on a simple plan to exonerate themselves and implicate Ms. Reed. They would tell anyone who inquired Mr. O'Keefe, quote, never entered the house, end quote, and hide evidence that he was there, including his body. Enough snow to track a cat. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the lawn from potential passersby. They've got lucky to testify to that. They've got receipts on all this, most of it. At some point further in the night, they carried or dragged Mr. O'Keefe's body to that same area in the yard, close to where one or more of them later claimed Ms. Reed dropped off Mr. O'Keefe earlier in the night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Ms. Reed's vehicle and then died as a result of exposure to the cold. Max says, the crash test dummy, you mean Rescue Randy, had more credibility than the weatherman. I did like the weatherman, though. Enough snow to track a cat. But I digress. Mr. O'Keefe was either dead when the House defendants left him on Albert's lawn, or he died shortly thereafter. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night. He later told investigators he had to do some, quote, administrative work, but then changed his story, subsequently stating that he drove to the station because he had to move cars in the parking lot due to the snowstorm. However, video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away. I want to bring something up here that may be unpopular, but those of you who know Sean McDonough, years ago, hold on, because I got to get my receipt on this, said, and a lot of things that Sean McDonough has said have happened, have actually come true, right? That there was something, refresh my recollection, chat, about a giant hockey bag that had something to do with Proctor, and it was confiscated from one of Proctor's friends' houses. Do you guys remember that? Little Cupcake took notes about it. Okay? Little Cupcake took notes. So, hold please, because this is interesting, because it kind of ties together when we saw in the video what looked like Brian Higgins carrying that big bag. And it had been brought up that perhaps that bag had been confiscated from Proctor's friend's house or something. Hold on. Let me just go back to my notes. Hold, please. Okay. Here's what I recall. Here's what Little Cupcake recalls, because Little Cupcake took the notes. Sean talked about this. Sean McDonough talked about this, I think, on his channel or somewhere in the fall of 2024. He said that the feds have comments in Proctor's phone talking about a duffel bag and how he had to get rid of it. Sean said that the duffel bag was taken by the feds in March of 2023 from the residence of a Proctor associate named Frank McDonald. 4 federal agents went to his residence and took possession of it based on text found in Proctor's phone. Aaron says, I think Sean on the golf knows a lot. Okay, so do you guys remember that? Frank McDonald. And then that's what Sean McDonough said. And then right after that, the duffel bag was allegedly taken by the feds in March of 2023 from Frank McDonald's house. The federal grand jury was convened a month later in April of 2023. I don't know. Sean McDonough has sources, and that just reminded me of that when it says here that the video, and we saw it, surveillance video from outside Canton PD reveals Higgins transporting a large bag from one vehicle to another before driving away. And I think that Sean McDonough even referred to it as like a hockey bag or something, right? He's got sources. But he said this a long time ago. I don't know if it's got merit, but I'm just, right? Mike Eo says, yep, I remember the feds supposedly have it. Let's see. Well, I'm not here to talk about whether we trust him or whether he's a good source. I'm just pointing out that he did say that, and that gave me, that's interesting to me now that we saw him with the large bag. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian Albert and Higgins denied the existence of these phone calls, and when confronted with their existence by a, quote, separate law enforcement agent, non-MSP and non-CPD law enforcement agency, at a separate proceeding, they coordinated the same exact lie, falsely claiming the multiple calls and answers were just butt dials. And we know that to be the FBI in their ice cream truck. However, 5 minutes after the Higgins-Albert call, Ms. McCabe performed a Google search on her phone at 2:27 a.m. Hoslong to die in cold, misspelling the first word. Dun, dun, dun. Next section is entitled Ms. Reed's Searches for Mr. O'Keefe. Ms. Reed began the search for Mr. O'Keefe on January 29th, just before 5 a.m. when she awoke and realized he had not returned home. She phoned House defendant Jennifer McCabe, who already knew exactly what had happened to Mr. O'Keefe. Ms. McCabe insisted that Ms. Reed drive to Ms. McCabe's house rather than driving to 34 Fairview Road, which Reed did. I remember this because we went over Jennifer McCabe's statements the other day. And didn't she in one of them say she told Karen to come over, but then on the stand she was like, she just showed up at my house. Karen's version. Karen's version is that Jennifer McCabe insisted that Karen drive to her house rather than driving to 34 Fairview. And she did. The two of them were then joined by Kerry Roberts, and the three of them left the McCabe residence. However, rather than go to 34 Fairview, oddly, Ms. McCabe directed them to go back to Mr. O'Keefe's home where Ms. Reed had just come from. After the three of them finally drove to 34 Fairview, the illogical McCabe-directed route to 34 Fairview was intentional. It allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Albert's lawn and first responders arrived. As they approached the house, with Ms. Roberts driving, Ms. Reed saw Mr. O'Keefe almost immediately. She screamed for Ms. Roberts to stop the vehicle and jumped from the moving car to run to Mr. O'Keefe. She began rendering aid, including CPR. As the House defendants had planned, Mr. O'Keefe's body was, quote, discovered in front of the Alberts house near a flagpole and fire hydrant on the left side of the Alberts property, as seen from the roadside. The Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. While Ms. Roberts joined Ms. Reed with administering CPR, Ms. McCABE did not even help or even approach Mr. O'Keefe. Rather, she sat in the cab of the vehicle, called 911, and reported that there's a man passed out in the snow. And I quote, despite knowing that her brother-in-law, Brian Albert, a police officer and first responder, was just feet away inside the house, Ms. McCABE never went into the house or requested that Albert come down to help Mr. O'Keefe. Rather, as Mr. O'Keefe lay dying in the snow, Ms. McCABE stood and watched with no fear, no urgency, or even concern for her family members residing mere feet away. Yeah, that is, to me, one of the strangest things about this case. If I was at my sister's house and one of my other friends is found dead on the lawn and I don't know how, and I don't know how it happened or how he died, you bet your ass I'd be running into that house to check on my sister and her family to make sure that there wasn't some crazy gunman who killed everyone inside that house, in addition to the guy who's also my friend who's laying on the front lawn. Especially if, as she says, she made 2 calls to Coco and a call to Brian and nobody answered. Come on. Come on. Might have been born at night, but not last night. Next section. Investigation begins. The Canton PD were first on the scene shortly after 6 a.m. At that time, there was no evidence that Mr. O'Keefe had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There were no bone fractures or trauma to his lower body, his torso, or any other part of his body, as investigators would expect from a vehicle strike. Rather, Mr. O'Keefe's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. For good reason, the ranking Canton PD officer on the scene, Sergeant Michael Lank, opined on a telephone call captured on a dash cam that Mr. O'Keefe looked like he had been in a fight. Did that come out of the trial? Because I don't remember that. Lank on dash cam saying, looks like he's been in a fight. I don't know. We've been through, well, Lank only testified at the first trial. And so it would have been in his testimony during the first trial. It came out? Okay. Moreover, the initial search conducted by Canton police officers revealed that there was no vehicle debris on the lawn at 34 Fairview, let alone any debris at or near Mr. O'Keefe's body. Not a single piece of taillight material was discovered on the lawn that morning or in the roadway, notwithstanding multiple searches and the use of a leaf blower to remove snow. Tellingly, despite the commotion outside, including more than a dozen first responders, 3 police cruisers, 2 ambulances, a ladder fire engine, all with their emergency lights flashing, and at least 2 civilian vehicles, plus Ms. Reed's screams upon finding Mr. O'Keefe's body. We heard those screams in the background of the 911 call. And dashcam footage. They're chilling. No one from the Albert's house, including police officer Brian Albert, even went outside to see what was happening, let alone help. They wanted to avoid scrutiny from the police investigators. Sergeant Lank was a longtime friend of the Alberts and the first law enforcement officer to enter the house. He spoke to the Alberts and the McCabes. Pursuant to their plan, the Alberts and the McCabes told Sergeant Lank that Mr. O'Keefe had never entered the Alberts' house the night before. The Alberts and McCABE statements were false. Mr. O'Keefe arrived at and entered the house or garage where he was assaulted, attacked by the Alberts dog, and suffered a fatal injury to the back of his head. Despite Mr. O'Keefe's injuries being wholly inconsistent with the story the House defendants were now telling him, neither Sergeant Lank nor any other member of the Canton PD searched the house to determine whether the occupants or anyone else were involved in Mr. O'Keefe's death. Nor did they request to search the occupants' cell phones, observe their bodies for evidence of a fight, or even secure the scene where Mr. O'Keefe's body was found. They failed to do so because of bias, born of friendship and loyalty in favor of the Alberts and McCabes. I have often referred to Sergeant Lanka, as the Ray Donovan of the Albert family, because going all the way back to the 90s and the Lopalato brothers, Michael Lank has been inserting himself into Albert family business and fixing things for them, in my opinion. After Sergeant, as the evidence showed, actually, at the first trial, after Sergeant Lank returned to the Canton PD 3 hours after the discovery of Mr. O'Keefe's body and more than 2 hours after being interviewed at the Alberts' home that morning, Ms. McCabe called Sergeant Lank to report that she recalled additional information. As part of the plan to implicate Ms. Reed and remove suspicion from the House defendants, she falsely told Sergeant Lank that Ms. Reed told her twice that morning, "I hope I didn't hit him." More than a year later, at a separate proceeding, Ms. McCabe changed her story on this topic yet again. Guess that separate proceeding would be the federal grand jury. In furtherance of the House defendants' plan, McCabe then falsely reported that Ms. Reed outright confessed to hitting Mr. O'Keefe right after she first found him in the snow. Amazing how stories just morph and change and time drifts and drift away. Let's go to the chat before we move on to the next section. Music to My Soul says, interesting that this statement does make it seem like the Alberts, McCabes, and Higgins all have the same legal team. Is that how you read it, Melanie? Well, the statement does not name any attorney, but it does say their attorneys. Now, we looked at the civil cover sheet earlier in the stream, the very first thing that we looked at, and it's got an attorney listed for Brian and Nicole Albert, Jennifer McCabe, Matt McCabe, and Brian Higgins, all the same person, James Tuxbury at Hinckley Allen. That may just be an attorney who agreed to accept service of process for them. In my opinion, it would be malpractice for one attorney to represent them all because they all have different legal interests. And so the statement that I read that Ted Daniel tweeted said attorneys. And so I'm not quite sure. I think it would be highly unlikely that they would all have the same attorney, highly unlikely, but they haven't filed their answers yet, so we don't know. Colleen says Norfolk County, check. Plymouth County, check. Essex County, check. Bristol County has now entered the chat. All of them, all the counties, all of them. Thanks, Colleen, for your super chat. Tracy, thanks for becoming a member. Jeannie says, great day to be alive. The Karen Reed case is the microcosm of the Epstein class corruption from Trump's American monarchy. So goes Karen Reed, so goes Ohio. Love from Ireland. Thank you for tuning in from Ireland, Jeannie, and for your super chat. Mandy, thanks for becoming a member. And Jeannie said, Karen Reed brought me to YouTube. So glad I found you, Melanie. Oh, I'm so glad you found me too, Jeannie. Antony, thanks for your super chat, says James Tuxbury, Hinckley Allen is the lawyer. Well, that is drafted. That civil cover sheet is drafted by the plaintiff's firm. So I don't want to spread misinformation because it's not confirmed that he's representing any or all of them. It is just what is written on the cover sheet by the plaintiff's attorney. And that is where they were served. And those are that's his address that was put on there instead of McCabe address, Higgins address, etc. So until I have confirmation of that, I just don't want to, I like to deal in facts and receipts. But I can see why you would think that. Catherine Smith, thank you for your 20. So Karen could theoretically bankrupt Canton. Take them down. She says, I'm praying they take them down because misery loves company. Technically, theoretically, I don't know if you can write a check big enough for Karen Read, do you? I mean, how much would somebody have to pay you? Think about it this way. How much would somebody have to pay you to endure what Karen Read has had to endure since January 29th of 2022? How much would they have to pay you for that? She had to sell her house, pay attorney's fees, liquidate her 401ks, lost her jobs, lost her retirement money, the pain and suffering, the violation of your civil rights. How much would somebody have to pay you? I mean, I don't know if they can write a check big enough. It's going to be interesting. 227 million. Vincent McCormick, thanks for tuning in from Canada and for your super sticker. I appreciate you. Lisa, thanks for becoming a member. Gigi says, side note, my granddaughter, Leighton, heard your music and ran in here. It's Miss Melanie. Gigi, I want to watch. I told her Bluey was on and she needs to watch. Oh, I'll keep it clean today for Leighton. And I love that name. And thank you so much. You're a very blessed Gigi. Thanks for your 10. An inverted sneaker is here and says, throwing down a hot 20. In my opinion, it looks like Higgins took the bag out of a rescue vehicle at Canton Police Station parking lot. A portable stretcher is stored in a bag like that. Oh, interesting. Did Higgins get the key to the rescue vehicle from Good? Ooh. Well, that would be an interesting tidbit to come out. I like that you're thinking outside of the box, inverted sneaker. Okay, moving on to the next section, which is entitled Proctor Leads MSP Investigation Despite Conflicts. This is my cursor on your screen, so please do not smash your television and send me a bill because that is my cursor. It is not a fly. Thank you, Nana of 5 for buying 5 matcha lattes. You're amazing. She says, thanks for all you do. Been watching since the first Karen Read trial. I pray for justice for John O'Keefe. And I think we all have that one common goal is we all want justice for John O'Keefe, right? We all want justice for John O'Keefe. And what does justice for John O'Keefe look like to you? Justice for John O'Keefe looks to me like the people or person who actually killed John O'Keefe suffers the consequences of that. And if there were people that covered up the murder of John O'Keefe, they too should suffer the consequences of that. But that's just me. Back to the papers. You got to download the actual fly cursor to mess with you. Is there such a thing, Robin? I didn't know there was such a thing. Yeah, and take down the corruption. Proctor leads MSP investigation despite conflicts. Michael Proctor was assigned as the case officer and had primary responsibility for the MSP investigation of Mr. O'Keefe's death. Sergeant YURY Bukhenik was Proctor's direct supervisor. Lieutenant Brian Tully was the supervisory officer at the Norfolk County State Police Detective Unit and thus supervised both Bukhenik and Proctor. In their roles, Bukhenik and Tully both knew at all times exactly the extent of Proctor's misconduct in investigating Mr. O'Keefe's death as described below. Oh, now we're going to hear what they knew. Take a breath. From the beginning, Proctor should never have been assigned as an investigating officer, let alone the lead investigator. He grew up and resides in Canton, is a good friend of the Alberts, and had known the family for years. Proctor and Julie Albert, Brian Albert's sister-in-law, had each other's personal cell phone numbers. In fact, just days before Mr. O'Keefe's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Remember how he tried to brush that off? Proctor's sister Courtney was also a close friend of Julie. In fact, Proctor's own mother referred to the Alberts as the Proctor's second family. The existence of these relationships was intentionally suppressed by Proctor and other members of the MSP, including Bukhenik and Tully, in an effort to ensure that the House defendants were protected and that Ms. Reed's right to a fair investigation and trial were undermined. Next section entitled Proctor, Bukhenik, and Tully engage in a corrupt and biased investigation by not investigating inside the House and interviewing House defendants as friends rather than suspects. I mean, really, you can't say it any clearer than that, can you? Proctor, Bukhenik, Tully, and the MSP never searched for DNA evidence inside the House. never looked for ridged surfaces that could have caused the gash on the back of Mr. O'Keefe's head, never inspected the House defendants' bodies for indication of bruises or cuts that resulted from an altercation, and did not search the House defendants' cell phones. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Proctor's, Bukhenik's, and Tully's interviews of the House defendants were also outside of normal protocol. They were all interviewed either at their home, their family member's home, their lawyer's home, in the case of Brian Higgins, their lawyer's office, in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. These interviews were untimely, unrecorded, and fundamentally designed to protect the House defendants. And the House defendants took full advantage of it. Specifically, Jennifer McCABE became the point person for the House defendants in providing their false narratives to investigators. She managed and communicated details about the House defendants' messaging and the investigation itself, including visiting Proctor's and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. They're calling her the ringleader. Indeed, these were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicate acts of a conspiracy among a group of people with a shared goal of deflecting their criminal exposure onto someone else. Because you know what we didn't see? We didn't see any text messages in the group of Brian, Nicole, Brian, Coco, Jen, and Matt. We didn't see any messages like, holy F, what do you think happened to him? I can't believe what happened. I can't believe this. No. We saw messages like, tell them the guy never went into the house. And the troopers are back, but they're at the Asian house. And I don't want to text about it. We'll find out more tomorrow. Never any messages about concern for John O'Keefe, Boston police officer found dead on your sister's lawn. Wild. They're never trying to figure out what happened to him. They're just trying to figure out what to say and what not to text about it. The remaining group texts that were not deleted or that were recovered later reveal some of their planning. For instance, on the evening of January 29th, Jennifer McCABE texted with her sister, Nicole Albert, that Kerry Roberts, who was present when Mr. O'Keefe's body was found, quote, talked to cops and kept it simple. Of course, there would be no reason to report back to the other House defendants about Roberts keeping it simple unless what really happened was more complicated. Proctor, Bukhenik, and the MSP never sought these communications. Rather, they were obtained by Karen Reed's defense attorney's repeated motions to compel access to data on Ms. McCabe's iPhone. Later, in group text with Jennifer McCABE and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter, saying, quote, ask Chris to ask some questions. Tell them the guy never went in the house. As an endorsement of the plan, Brian Albert responded, exactly. More importantly, the text messages from the House defendants' phones that were ultimately recovered and that provide a window into their conspiracy and misconduct, as well as MSP's unlawful investigation, were not the product of Canton PD or MSP's investigative work. Rather, based on media reports raising serious questions about MSP's investigation and the House defendants' role in Mr. O'Keefe's death, another, quote, separate law enforcement agency, which we know to be the FBI, began its own subsequent investigation. That investigation, and not MSP's, resulted in obtaining the House defendants' phones, taking statements from the House defendants, and conducting a, quote, separate proceeding, all of which MSP refused to do itself. I didn't know I didn't know that the FBI got the phones of everyone that was in the house. Did you know that? Obtaining the House defendants' phones? Hmm. Indeed, the evidence procured by the, quote, separate law enforcement agency's investigation demonstrates the House defendants' conspiracy and unlawful conduct, as well as MSP's bias and corruption. Proctor and Buchanan initially interviewed the McCABEs and Alberts on January 29th at the McCABE's home on 12 Country Lane in Canton, at which time they again falsely stated that Mr. O'Keefe never entered the Alberts' home. Buchanan and Proctor did not interview Nicole Albert and Brian Higgins till February 3rd, 2022, and did not interview Chris and Julie Albert until February 10th, nearly 2 weeks after Mr. O'Keefe's death and more than a week after Miss Reed was arrested and charged. Before both interviews, the McCABEs and Alberts continued to coordinate their stories, as evidenced in group texts. One sec. Coordinating all the stories. Proctor, Buchanan, and Tully likewise failed to conduct a meaningful investigation into Higgins' involvement. When Proctor and Buchanan interviewed Higgins on February 3rd, they didn't even interview him until after Karen Reed's arraignment. We watched her arraignment the other day again. And in that arraignment, Lally said that on January 29th, 2022, Proctor and Buchanan went to the scene at 34 Fairview. He said that. And of course, Michael Marcy vehemently denied that in his hostage video that he put out in August of 2023. When Proctor and Buchanan interviewed Higgins on February 3rd, Higgins presented the troopers with a select set of self-curated texts between himself and Ms. Reed. They learned that Higgins and Ms. Reed had been exchanging flirtatious texts and that Higgins reported at least one instance in which Ms. Reed and Higgins had kissed while at Mr. O'Keefe's house mere weeks before his death. Rather than pursuing Higgins as a possible suspect, Proctor, Buchanan, and Tully neglected to investigate the matter further. They never interviewed Higgins again, even after surveillance video revealed Higgins was suspiciously hiding his face in the halls and the parking lot of Canton PD at 1:30 a.m. on January 29th. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buchanan, Tully, and MSP not investigate what Higgins was doing or what was in the bag, but they went so far as to hide this video from Karen Reed and her criminal defense attorneys for years. Reed's defense did not receive these videos until after Reed stood trial for the first time. And even after the separate law enforcement agency's investigation revealed late-night phone calls between Brian Albert and Brian Higgins, MSP failed to pursue either witness further or seek a full forensic extraction of Higgins' phone or even a simple call log from his cellular provider. I mean, think about it. Think about it. All that stuff was turned over by the feds to both sides in the Karen Reed trial in February of 2024, before the first trial. And so Adam Lally had it. And we know that the troopers assigned to the Norfolk DA's office are assigned to the Norfolk DA's office, and they are an extension of the prosecution. And they had all of that information. And even after they had that information, they still did nothing to investigate anybody else for the murder of John O'Keefe. Think about that. And the reason that all of this stuff was turned over by the feds is because Josh Levy, who was the acting U.S. attorney at the time for the state of Massachusetts, said to both sides in a conference call, in good conscience, I cannot allow this case to go to trial. And so he turned over 3,000 pages of evidence and discovery, including these messages, these phone calls, these butt dials, the ARCA reports, because I think Josh Levy thought there's no way in hell they're going to prosecute Karen Reed for this. Look at all the evidence that he wasn't hit by a car. Look at all the suspicious behavior of all the other people who were in the house. Any honorable district attorney would have dropped the case, right? Would have dropped the charges, but they didn't. They doubled down and they never even tried to investigate further, even after presented with all that other evidence. Think about that. He was giving them an out, Josh Levy was. And if you think the FBI is done, think again. And it's my opinion that he only gave them just enough, that they've got so much more, the FBI. They only gave both sides just enough to make Michael Morrissey think to himself, you know what? John O'Keefe wasn't in by a car. What am I doing? What am I doing here? He didn't do it. He didn't take the bait. He didn't take the bump or the nudge. No, he doubled down. And if you think they haven't been watching everything that's happened since, I don't know. I got a bridge to sell you in Brooklyn. When it was revealed that Ms. Reed's defense team requested the preservation of Brian Albert and Higgins' phones in order to forensically image them, this request was allowed by the court. Both men got rid of their phones within days of one another. Higgins went so far as to drive to a military base on Cape Cod, remove the SIM card from the phone, cut the SIM card with scissors he brought with him, and destroy and dispose of the phone and card separately in 2 dumpsters and then drive back home. Their destruction of their phones eliminated potentially incriminating communications between them and was a direct result of Proctor's, Bukhenik's, and Tully's intentional refusal to collect important investigative evidence that would be exculpatory to Ms. Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues they could have used to pursue evidence, such as cellular toll records, or simply interviewing Brian Higgins and Brian Albert to inquire about the nature of the late-night communications. They intentionally ignored these avenues as well. Not only did Proctor fail to probe his friend's stories, he coordinated with them through his sister. Proctor spoke to Courtney multiple times a day and knew she was in close contact with him, providing information to Julie Albert. Julie and Courtney called each other many times between February 1st and 2nd, and at least 67 times between February 1st and September 6th, 2022. For example, as he prepared to question Chris and Julie Albert on February 10th, Proctor told his sister Courtney that the interview was, quote, not a big deal. Courtney told Proctor that Julie Albert had been nervous and wanted to give him a thank you gift after the interview. To avoid scrutiny, Proctor instructed Courtney to tell Julie to give the gift to his wife, Elizabeth Proctor. Proctor shared investigatory details with Courtney before they were public. In the same instance referred above, or referenced above, when his sister informed him that Julie Albert had been so nervous before the interview, instead of investigating further, he shrugged it off, laughed, and asked why. But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that it was fine, just a quick convo. And then, after the interview, Proctor spoke to Julie on his personal cell phone in an unreported conversation. Oh, yes, he did. Proctor never treated the Alberts as witnesses in a murder investigation. He treated them like the family friends that they were. I think that Lori Dean is saying it best. She says, this is so good. This is so good. You want Karen Reed to tell her story? This is it. This is her story. She's telling it. It's going to take 46 pages, but she's telling her story. And here it is. And a lot of this stuff we already knew. Some of it we didn't know. A couple things that are new to me. At one point leading up to some of the interviews, Ms. McCABE asked Nicole Albert if she had heard anything more about the investigation. Confident she would learn more from Julie Albert, again through Courtney, Nicole responded, "We'll get more info tomorrow. Don't want to text about it." Everyone watching, thank you, Allie. Smash the subscribe and like button if you haven't already, please, and thank you. Helps the algorithm. We are on a quest to 130,000 subscribers, and we're so close. We're so close. We're at 129,658. You think we can do it today? I think we can. There's over 10,000 people watching, and I know not all of you are subscribed. It's free. Just hit that little subscribe button. There's 11,833 people here. We can do it today. We can bust through the 130,000 mark. I have faith in you, and I love you with all of my heart. And if I don't see you soon, I'm going to die. House defendants did not want to text about their activities and communications because they tried to hide and or lie about them. For instance, it was discovered in the second criminal trial that Ms. McCABE had lied in her sworn testimony in the first trial about not visiting 34 Fairview with Kerry Roberts on January 30th on their way to Michael Lank's house. That is right. It is a Godfather quote. It is from the Clemenza's meatball scene. You know. If you know, you know. Michael, tell the pretty girl you love her. I love you with all of my heart. If I don't see you soon, I'm going to die. However, while they did not text about this meeting, McCabe's cell phone location data, obtained later by Reed's defense, reveals that she did, in fact, visit 34 Fairview just one day after O'Keefe's death and lied about it. The McCabes, Alberts, and Higgins all told the same false story to investigators in their interviews, and Proctor, Buchanan, and Tully accepted their coordinated statements without making efforts to corroborate their stories. Next section. Rather than investigate their friends and brethren, Proctor, Buchanan, Tully, and MSP target Karen Reed. Instead of taking the routine, objective, and necessary steps of investigating the McCabes, Higgins, and the Alberts, Proctor, Buchanan, and Tully focused exclusively on Ms. Reed as a suspect from the start of the investigation, despite substantial evidence exonerating her and implicating others, just as the House defendants intended. Proctor seized Ms. Reed's cell phone and her SUV within 30 minutes of interviewing her on January 29th. He arrested her 72 hours later before reviewing any surveillance from the bars or ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's official conclusion that the manner of death could not be determined and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. That's right. But we know that he called for the tow at around 2 p.m. And he hadn't even, according to him, gone to 34 Fairview. It'll be interesting to see what Proctor's location data from his cell phone extraction shows and how many other lies he's going to be caught in. Right? Won't it? What time did he call for the tow? 2? 2:30? Based on Jennifer McCabe's statement that Karen Reed's taillight was cracked. We went over the original witness statements again the other day. Go look for that video if you haven't seen it. It was great. $2:30, he called for the tow, right? And then we found something else real interesting. In Barros's report that he drafted for the Dighton PD, Proctor asked Barros to contact a tow company, and he did, Diamond Towing. What Nicholas Barros also did was call Tom Ferry, the superintendent of highways in Dighton, to come and plow the driveway so that they could get Karen Reed's car out because there was so much snow by that time in Dighton. So Corey Hopkins and I got together and we said, did anybody ever request any dash cam footage from Tom Ferry, the superintendent of highways, who plowed Karen Reed's parents' driveway? Because if he had a dash cam, wouldn't it show the condition of the rear of Karen's car? Because it was ass out. It was ass out. And Corey requested it, and we were told by Tom Ferry that they don't have dash cam footage. They don't have dash cams. But wouldn't that have been crazy? Much to Proctor's surprise, through the separate law enforcement agency's investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends on the evening of January 29th, the day he began his investigation. He told them that the MSP had already determined the Alberts were not going to receive any scrutiny about Mr. O'Keefe's death, even though the MSP had not at that point visited the crime scene or had been inside the Alberts' home, and had performed only a cursory interview of the McCABEs and Alberts. Proctor told his friends that Mr. O'Keefe had been hit by a car and had not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with a vehicle strike, but he did have injuries consistent with a fight and a dog attack. Proctor rejected a friend's belief that Brian Albert, the homeowner of the property where Mr. O'Keefe's body was found, would receive some shit, instead agreeing with another friend's assumption that, quote, you guys, the MSP, are out to make it cut and dry since it involves cops. Proctor revealed that he had already decided that he was, quote, going to put serious charges, end quote, on Ms. Reed, and that she was effed, and that there was zero chance she skates. From the outset, Proctor was determined to pin it on the girl. Proctor's supervisors were aware of his bias and conflicted relationships in this investigation. They didn't have to guess. Proctor told them. He told them he knew the Alberts. Text messages from Proctor to Bukhenik and other MSP troopers show Proctor had decided to focus suspicion on Ms. Reed to the exclusion of everyone else. He told the troopers that Ms. Reed was the R word and that he was searching her phone for nudes of her. In the text chain, Sergeant Bukhenik liked Proctor's text describing Ms. Reed as the R word. Bukhenik received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct, because he was determined to put serious charges on Ms. Reed. Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide. Well, excuse me. Pardon me. Excuse me. Pardon me. Because he was determined to put serious charges on Ms. Reed, Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide, determining instead that the manner of death could not be determined. The medical examiner also refused to conclude that Mr. O'Keefe died as a result of being struck by a vehicle, and later testified at trial that his injuries were not consistent with a car strike. We know, we were there. Proctor later admitted that in his entire career, he had never seen a homicide investigation where the medical examiner could not determine the manner of death. But he remained undeterred in his quest to charge Ms. Reed. As he later admitted, the medical examiner's refusal to rule the death a homicide did not matter to him, quote, because either way, Ms. Reed was going to be charged. It's telling a story. It's telling the story. Next section, entitled Proctor and Bukhenik Plant Certain Evidence and Make False Statements in Court and Other Legal Documents to Frame Karen Reed. Oh, they're going to allege that Bukhenik also planted evidence. I can't wait. Can you? Can you wait? Proctor made this investigation cut and dry by manufacturing a case against Ms. Reed. A crucial first step was to ensure that the crime scene and evidence was not secured. This was in violation of MSP policy and well-established best practices for critical incident investigations. Specifically, the MSP Crime Laboratory requires proper processing of evidence at major crime scenes, including crime scene photography and evidence processing, and recovery of latent fingerprint, footwear, and tire track evidence. Neither the MSP troopers involved in the investigation nor the Canton PD police officers on the scene secured the Alberts' home or the area where Mr. O'Keefe's body was found. The MSP did not take any photographs of the house, including any part of the yard where O'Keefe's body was found, until February 1st, more than 3 full days later. But wait, some of you might be saying, there were pictures of the outside of the blood droplets and the leaf blower. Those were taken by Canton PD. This sentence specifically states the MSP did not take any photographs until more than 3 full days later, February 1, the day that Karen Reed was arrested. No photographs were ever taken of the inside of the garage of 34 Fairview. This intentional departure from established protocols permitted Proctor and Buchanek to generate false incriminating evidence against Ms. Reed and give the House defendants time to destroy the actual evidence. By approximately 2:30 p.m. on January 29th, before he had even met or interviewed Ms. Reed or seen her Lexus SUV, Proctor had already ordered seizure of the vehicle at her parents' home in Dighton. By 4:17 p.m., the vehicle was in MSP's physical possession. The vehicle was then towed to the Canton PD Sallyport, even though the MSP has at least 2 closer barracks, and Massachusetts was in the middle of an historic nor'easter. Proctor knew he had more leeway to manipulate evidence regarding the SUV at Canton PD than at MSP's facilities, and he knew he needed to have that evidence in close proximity to the crime scene at 34 Fairview Road. Before the vehicle arrived at the garage, or garage, however you prefer to say it, Ms. Reed's Lexus taillight had a minor crack but was intact. The crack occurred when Ms. Reed backed into Mr. O'Keefe's car at 5 a.m. that morning as she was leaving to search for him. That incident was captured on video. Buchanek and Proctor followed the vehicle from Dighton and arrived at Canton PD at 5:35 p.m., just moments after the tow truck with the Lexus. At some point after the vehicle arrived at the Sallyport, the right rear tail light was almost entirely destroyed. Video taken from different angles in the Sallyport shows Buchanek, Proctor, Canton Police Chief Ken Berkowitz, and other individuals near the taillight, but notably, no video captures the taillight's appearance at the precise time it arrived at the Sallyport. The available surveillance video from the Sallyport, as well as Canton PD, as well as a Canton PD access card swipe log obtained by a separate law enforcement agency, the FBI, reveals seemingly unfettered access to the Sallyport by a myriad of individuals throughout the evening of January 29th, including just before and after 5:30 p.m. One or more of them, destroying the taillight, secretly took pieces of it into their possession and then planted some of them in various places at 34 Fairview and on Mr. O'Keefe's clothes. Knowing that there were video cameras both inside and outside the Sallyport, Proctor and Buchanek worked together to obscure their role in manipulating the right rear taillight and then ultimately to present false evidence at the first criminal trial. Oh, it's getting good. Focus your attention if your mind has wandered. Specifically, Proctor directed Buchanek to secure video footage from surveillance cameras located both inside and outside the Sallyport garage, which he did. These videos were manipulated in 2 significant ways. First of all, isn't Buchanek the supervisor, but Proctor is directing Buchanek? First, a critical 42-minute portion was deleted from the footage from the Sallyport front wall camera. The portion from 5:08:02 p.m. to 5:50:50 p.m. which included the exact time Ms. Reed's Lexus arrived in the garage. This footage would have shown that the taillight was intact. Second, footage from the Sallyport back wall camera was inverted, which made the right side of Ms. Reed's vehicle appear to be the left side and vice versa. Oh, yeah. Another camera, main driveway side exterior, captured the back end of the Lexus as it arrived at Canton PD, but was too grainy to decipher the condition of the passenger taillight. Refresh my recollection, but wasn't there also recently an email that surfaced and maybe one of Corey Hopkins' FOIA requests in which there was an email maybe from Proctor? Was it Proctor to Colleen Crawford? Thanks for helping me with that video or something like that. Correct me in the chat. I remember seeing something like that in passing. Yes. Was it between Proctor and Colleen Crawford? Yeah. Here's another thing. Colleen Crawford is on the witness list for the Brian Walsh trial. So if you're not following that with me, you want to follow that with me. Colleen Crawford's on the witness list. Yep. She replied, no problem. He said something like, thanks for helping me open that video or something such as like that. And she replied with, no problem. Anytime, Mike. You guys are so collaborative. Thanks for helping me with the video. And she replied, anytime, Mike. Oh, and it's a good time to point out too that Colleen Crawford and John Fanning have had at least one or two businesses together. They've been in business together. There's corporate documents. Fanning and Crawford that have to do with video editing services or something such as like that, right? Yeah, there's corporate documents. One of those corporations was in fact dissolved, I believe, the day that Karen Reed was arraigned on February 2nd of 2022 or something such as like that. Do you remember? Oh, and do you also remember when we covered the, yeah, just a little side quest here. The murder of Keith Boudreau, which occurred in a Quincy hockey bar somewhere around, I don't know, 2014, 15, 16. It's all coming back to me now. A man named Paul Fahey was on trial and was convicted of the murder of a guy named Keith Boudreau for stomping on his head in a bar in Quincy. And what had happened was there was a civil case that resulted from that where the family of Keith Boudreau sued Paul Fahey. And Paul Fahey filed a motion saying that Colleen Crawford and John Fanning manipulated the video from the bar in his case, that they went to the bar in Quincy and physically seized the entire surveillance system from the bar and manipulated the video. We looked at that motion so long ago. I don't know how I remember all of this. I don't know. Sometimes I misremember and then I ask you to help me. But this is all true. Somebody says AJ needs to know this. I'm sure he does. Karen, listen, Karen knows her case like nobody else. She knows everything. I wouldn't be surprised if she had a full-throated assist in drafting this complaint. Wouldn't be surprised one bit. Why is it they still cannot acknowledge the FBI? I think because at the end of this case, it is going to have to be determined when the case goes to trial, if the case goes to trial, whether or not they're going to be allowed to talk about the FBI. And so leaving it out of the pleadings is a smart thing to do in case it is ever ruled that they are not allowed to mention the FBI. And so these pleadings will be attached to motions and other filings in the case. And so it's just a smarter way to do it for now. For now. Fanning and Crawford had a side business. At least two of them. There was more than one, I believe. Hold. It's just a smarter way to do it for now. Back to the document, paragraph 79. The videos from inside and outside the Sallyport and Proctor's request for Buchanan to obtain it was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung on them immediately before and during the first criminal trial. One driveway camera's footage was not revealed to the defense until just prior to the start of the second trial. In fact, Buchanan presented one part of the video during his direct testimony under questioning by the Assistant District Attorney Adam Lally. Buchanan narrated the video to the jury, correctly identified that Proctor was at the right rear of the vehicle, but claimed that he never approached the right rear taillight area of the vehicle. That testimony, however, was entirely false. As he well knew, the video that Buchanan authenticated as fair and accurate was neither fair nor accurate because it had been inverted. Proctor was actually behind the right taillight for a significant period, but because it was inverted, it appeared in the video that he was behind the left taillight. They hoped this would allow Buchanan to lie about this issue at trial without detection. With this video and Buchanan's false testimony, the MSP, Proctor, and Buchanan attempted to mislead the jury in order to conceal the tampering with and planting of taillight material. Right. Sue LW 65 says Colleen also left a post-it note on the disc for Proctor that said something like, "No tampering, LOL." Wait, was it Colleen Crawford the one who did that, or was that Helena Rafferty? Can't remember who did that, but there was a post-it note that said "No tampering, LOL" on it. I can't remember everything, so I have to rely on you guys for some things. That was Rafferty. Okay, good. It was Rafferty. Thank you. And I remember YURY Bukhenik on the stand when he was being crossed by Alan Jackson. And Alan Jackson said, "Well, you lied, didn't you? That's not a fair and accurate representation of the way the Sally Port looked because everything is inverted. It's backwards." And YURY Bukhenik's cocky answer as he said, "Well, it's like looking in a mirror. It's like looking in a mirror. Everything's like backwards, but it's like still there." English is his third language, after all. We learned in trial number 2. And that is why the release of these sidebars is so important, because there was a sidebar about that inverted video, and I'm dying to know what they talked about at sidebar. Aren't you? Back to the papers. Proctor and Buchanan also took taillight pieces from the Sally Port, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found, and then falsified various documents in an attempt to hide their conduct. So they're falsifying documents too. In warrant applications to the Stoughton District Court and Norfolk Superior Court for searches of Google's electronic records, ring videos, Ms. Reed's phone, Ms. Reed's vehicle, cell tower records, and other sources of information, Proctor swore he seized Ms. Reed's vehicle from her parents' home at 5:30 p.m. on January 29, 2022, and had the vehicle towed to the Canton PD. Reports shared by the Dighton PD in 2023 reveal that the Lexus was towed from Dighton at 4:17 p.m. Proctor's assertion that he seized it at 5:30 p.m. was intentionally false to hide the fact that the car was in police custody for 73 minutes longer than indicated in his sworn affidavits. They're telling us everything. They're telling us everything. So much of this stuff was not allowed in during trial number 1 and or trial number 2 and or both. And civil cases are so much broader and so much more generous with discovery, so much more generous with discovery. Burdens of proof, etc. Do you remember what Proctor called it? Do you remember what Proctor said when questioned about the time being wrong? Scrivener's error, a typo. Proctor maintained that false narrative because it would hide the exact time frame when he had the opportunity to remove pieces of the taillight from Ms. Reed's vehicle and bring them back to the house so that he could later claim the pieces had been there since approximately 12:30 a.m. on January 29th. However, unbeknownst to him, driveway video from the Reed residence in Dighton and a report written by the Dighton police revealed Proctor's lie and revealed the true and accurate time the Lexus SUV came into MSP's possession. Proctor also deposited the SUV taillight pieces that he and others removed from the vehicle in the Sally Port on Mr. O'Keefe's clothes. Proctor retrieved Mr. O'Keefe's clothes from the floor of the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or bag, as protocol requires, Proctor and Buchanan drove them around in his car all day and then placed them in the Norfolk County District Attorney's Office for at least 6 days, where they were accessible to Proctor, Buchanan, and any other MSP troopers. Proctor and Buchanan failed to create a log to document the chain of custody of the clothing. Therefore, and by design, there is no record of when, how many times, and under what circumstances Proctor and Buchanan touched, manipulated, handled, or otherwise tampered with that clothing. They gaslit everyone into believing that they don't do that there. They don't have these chain of custody logs. But we found something real interesting as I was going through the Justin Root case. Justin Root, 41-year-old man who was assassinated by 4 or 5 Boston police officers and 1 MSP trooper back in February of 2020. And we found, as I was going through the documents, a 10-page chain of custody report. It's literally a form in their computer. And you know who did the Justin Root investigation? MICHAEL Proctor, John Fanning, and YURY Bukhenik, and David DeCicco, and Garino, and their names are all over that chain of custody log. So they know how to do it. They knew how to do it in 2020. We saw a copy of it. We were floored. And they didn't do it here. The MSP Evidence Submission Handbook dictates that chain of custody begins at the time of collection and that the collector seal evidence packages as soon as possible after collection to ensure integrity of evidence items and limit loss of transient evidence. Here, in violation of MSP's stated policies, the chain of custody for all of John O'Keefe's clothing, as well as dozens of pieces of taillight material, does not begin until March 14th of 2022, nearly 2 months after it was collected, when Proctor finally submitted it to the MSP crime lab. Wow. At some point before providing those clothes to the crime lab, Proctor and or Buchanan placed pieces of the taillight on them, where they were then identified by the crime lab in 2023. Yeah, they didn't even test that stuff, remember, until 2023. Chain of custody doesn't start until 2 months after it was collected. It's not a far leap for a jury, is it? I don't think so. Proctor also planted pieces of glass on the bumper of Ms. Reed's SUV while it was in his possession at the Canton PD Sally Port garage, which he then claimed to have recovered later on February 1st. Proctor planted this evidence to make it look like these shards originated from a cocktail glass that Mr. O'Keefe was holding when he exited the Waterfall bar. Evidently, Proctor did not plan on Karen Reed's defense attorneys insisting on forensic testing on the glass shards, which showed that they did not match the cocktail glass in Mr. O'Keefe's possession. In fact, the 5 glass pieces originated from multiple different sources. Didn't match anything. But boy, did they push that narrative out there on the cesspool of Twitter and social media, and they got it into mainstream media. The glass on the bumper must mean she hit him. He had a glass with him. The glass on the bumper did not match the cocktail glass. In fact, the 5 pieces found on the bumper originated from multiple different sources. That glass chart was fire, Leah. Yes, it was. One shard of glass on the bumper did match another piece of glass that had been in Proctor's possession during the investigation. The only way for the glass to have ended up on the SUV bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of Mr. O'Keefe. Next section, other aspects of the conflicted and corrupt investigation. Proctor's, Buchenek's, and MSP's investigation was rife with other examples of corruption and bias. For example, despite evidence that Brian Albert may have had video surveillance at his house, neither Proctor nor Buchenik nor any other member of the MSP issued subpoenas to Ring or any other home surveillance company, and no one questioned any other member of the Albert family about the presence of video monitoring. I mean, just like use your common sense. I used to say that when I was picking a jury. Now I'm retired, so I don't have to say it anymore. But when you're a jury, you don't leave your common sense at the door. Use your common sense. Do you think that a Boston police officer who lives in Canton does not have any video home surveillance and just leaves his doors wide open and unlocked? Come on. Come on. Proctor and the MSP also failed to track down other important witnesses and evidence. For example, Brian Loughran, a town of Canton snowplow operator, turned out to be one of the most significant witnesses in the entire criminal trial. Proctor and his colleagues never spoke to him during their investigation and only did so once Loughran was interviewed by a, quote, separate law enforcement agency and provided statements inconsistent with the MSP's narrative 18 months after Ms. Reed was already indicted and awaiting trial. Specifically, Mr. Loughran, Lucky Loughran, put some 4-leaf clovers in the chat for Lucky. We love Lucky. Specifically, Mr. Loughran, now I'm thinking of Lori Loughran from Full House and the whole Ivy League scandal. Specifically, I'm just going to call him Lucky. Lucky drove his snowplow by the house multiple times in the early morning hours of January 29th, including at 2:30 a.m. and 3:30 a.m. He reported that there was no body on the lawn at 34 Fairview, nor cars on the street in front of the house at 2:30. Mr. Lucky believes he would have seen a body had it been on the lawn where Mr. O'Keefe was found several hours later. Instead, the second time he drove by the house around 3:30 a.m., Lucky saw a Ford Edge in front of the Alberts' home that had not been there an hour before, but which was then parked where Mr. O'Keefe's body was later found. Brian Albert drove a Ford Edge at the time. Again, jurors, use your common sense. Lucky's already testified to this. It's not going to be hard to prove that Brian Albert had a Ford Edge at the time. However, the Ford Edge was gone by the time Ms. Reed arrived to the house around 6 a.m., and in its place, she discovered Mr. O'Keefe's body. Proctor, Buchenik, and Tully never made any effort during the actual investigation to track down Mr. Loughran or any information relating to the Ford Edge. Fun fact, Lucky Loughran's brother sits on the Canton Town Select Board with Chris Albert. There are no coincidences in Canton, my friends. There are none. None. Proctor also secretly made efforts to protect other family members during the investigation who may have had a role in Mr. O'Keefe's death. Witness Julie Nagel told Proctor that Colin Albert, Brian Albert's nephew, had been present. Oh, not anymore. Who's not on the board anymore? Wait, I don't want to spread rumors. Hold on. All right. Isn't who gone? Michael Loughran or Chris Albert? Lucky's, I don't know. He was at the Canton Select Board meeting, like the last one that we covered. He's still there. Thank you. He's still there. Yeah, let's not start rumors. Some people, oh, never mind. All right. Witness Julie Nagel told Proctor that Colin Albert, Brian Albert's nephew, had been present at the house the night of January 28th through the 29th. But Proctor omitted his name from his official summary of Ms. Nagel's interview, even though he listed all others who had been present at the house with Colin. When Ms. Reed's attorneys filed a motion to obtain Proctor's notes, his handwritten memorialization of the Julie Nagel interview mirrored almost exactly what was typed up in his police report, except for the words Colin Albert. Oh, so Proctor did have written notes. Colin Albert's name was in the notes, but not in the report. Use your common sense, jurors. Why would he leave out the name Colin Albert? Maybe somebody asked him to. Doesn't mean that Colin Albert did anything. Maybe someone asked him to. Or he's just the suckiest investigator on the planet, which also may be true. I haven't decided yet. Change my mind. Proctor's interactions with Kevin Albert, Brian Albert's brother, during the investigation also demonstrate his close relationship with the Albert family, as well as his propensity for violating MSP rules and Massachusetts criminal laws. Repeatedly, Proctor used his personal cell phone to speak with Kevin, the Canton PD officer, instead of official channels when he coordinated interviews of witnesses, even though Canton PD was recused from the investigation. Oh, I guess they got those phone records as well. Proctor calling Kevin Albert. Didn't Kevin Albert arrange the only interview of a non-family member prior to Karen Reed's arraignment, which was Katie McLaughlin, the EMT / firefighter who went to high school with a girl named Caitlin Albert? Further, in the middle of Proctor's investigation in the summer of 2022, it was discovered that Proctor and Kevin Albert were out together drinking alcohol and driving Proctor's cruiser on Cape Cod. At the end of the night, Kevin Albert forgot to bring home his gun and badge and left them in Proctor's cruiser. Their drinking and driving in Proctor's MSP vehicle violated both MSP policies as well as various Massachusetts criminal statutes, and further highlights the conflicted nature of MSP's investigation. Dude, where's my gun? Dude, I'm so hungover. Have you seen my gun? Proctor's like, no, dude, but your badge is in my cup holder. And Kevin Albert's like, okay, dude, could you just drop it off in my mailbox? I'm summarizing. Also, we found out the other day that it seems that Michael Proctor may have shut off the GPS tracker on his cruiser that day that they went to investigate a cold case that we found out really does exist in the disappearance of Michael Mosher. But we found out that he did turn off his GPS during that little outing that they had. Moreover, because of their close relationship, Proctor, Buchanan, and Tully worked together with the Canton PD in hiding certain videos from Karen Reed's criminal defense team. Specifically, upon information and belief, Massachusetts, this should probably say MSP, and CPD collaborated to keep exculpatory surveillance video from Karen Reed's criminal defense team in preparation for the first trial. Those videos captured Brian Higgins' activities in the Canton PD parking lot and inside the police station shortly after the physical altercation at the house that led to Mr. O'Keefe's death. They demonstrated that Higgins' statements about his post-house party activities on the night of Mr. O'Keefe's death were not accurate. Upon information and belief, Canton PD knew it had this evidence and worked with MSP to keep it from Ms. Reed. Additionally, upon information and belief, Canton PD set its auto-delete function for saving certain surveillance videos from the Sally Port to 30 days, therefore assuring the immediate destruction of likely additional exculpatory evidence. The 30-day auto-delete setting conflicts with the fact that Canton PD videos were shared with the defense over the course of 3 years. That's right. All of a sudden, they magically appeared. Magical mysteries, Sally Port videos just magically appeared. Magically delicious. On the retired detective's hard drive, named Sergeant DGM Pietro, remember? I do. Therefore, either the setting was changed to prevent a defense expert from auditing the footage, which is when the 30-day setting was discovered, right? When they sent their expert there. Remember, they tried to get their cost back and Judge Canoni said no. Or the footage was obtained within 30 days of January 29th and withheld from the defense. Pick one. Pick one. Neither one is good for the defense. Next section is entitled The Indictments, Trials, and Aftermath. We have a lot to go through. I'm going to make it. Don't worry, I'm going to make it. It's so good, though. I mean, we just can't stop now, right? Ms. Reed was arrested on February 1, 2022, pursuant to a criminal complaint charging her with manslaughter, among other charges. She was required to post $50,000 for bail, and the court imposed several other conditions of release, including loss of her driver's license and stay-away orders from the O'Keefe family and John O'Keefe III's home. Note what she did not have. Also, it's Kelsey Fitzsimmons' birthday today, so happy birthday to Kelsey Fitzsimmons. She's turning 29 in the Chicopee Women's Correctional Facility, and she's been separated from her infant for since June 30th. So happy 29th birthday to Kelsey. If you can, please contribute to her defense fund. Unlike Kelsey Fitzsimmons, Karen Reed was not subjected to any alcohol testing, even though her charges allegedly involved alcohol. She was not subjected to an ankle monitor or house arrest, even though she was charged with eventually murder. And so you can see why we call Massachusetts, where your constitutional rights go to die, and there's no uniformity. And the laws are just, interpreted differently depending on what county you're in and who you are as a defendant. Hold on. Ms. Reed was later rearrested on June 9th of 2022 after being indicted for second-degree murder, manslaughter, and leaving the scene of an accident resulting in death. Her bail was set at $100,000 by the Norfolk County Superior Court. In February of 2023, her bail was reduced to $80,000 at the defendant's request. Remember, we watched that hearing. They were like, Your Honor, could you please reduce some of the bail and give Karen Reed $20,000 back because she needs to pay for experts and her attorneys and such. Ms. Reed was tried twice by the Commonwealth. The first trial started in April 2024 and ended on July 1st after the court ordered a mistrial because of a hung jury. On June 18th, 2025, following another nearly 2-month trial, Ms. Reed was acquitted of all charges associated with the death of John O'Keefe, murder, manslaughter, and leaving the scene of an accident resulting in death. For the first time in 3.5 years, Karen Reed was able to leave the court knowing that the forces aligned against her had failed to convince a jury to buy into or to buy their deception. Beginning in January 2022, the defendant's actions have had profound effect on Ms. Reed. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car and her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed. She incurred multiple millions of dollars in debt for legal fees and additional millions in expert fees and costs. In addition, after being arrested twice, jailed twice, and tried twice, she has suffered years of intense stress and emotional harm, worried that she would be imprisoned for the rest of her natural life for a crime she did not commit. Again, ask yourselves, how much would someone have to pay you to lose all of that and to go through all of that? And that's the check they're going to be asking the jury to write at the end of this case. Ms. Reed suffers from both Crohn's disease and multiple sclerosis. As documented under seal with the criminal court, Ms. Reed has undergone tens of surgeries to manage her illnesses prior to January 29th, 2022, and endured a blood infusion just months before Mr. O'Keefe's death. In the aftermath of the charges, 2 arrests, and during both trials, Ms. Reed suffered a well-documented exacerbation of her symptoms amid the stress, anxiety, and emotional and physical impacts of being wrongfully accused of murder. While fighting for her freedom against a corrupt prosecution, Ms. Reed underwent dozens upon dozens of documented medical procedures and treatments to attempt to address her health issues. That is something that I did not know, and that is something that is tragic. Anybody who has Crohn's or MS knows that stress can exacerbate both of those conditions. And both of those diagnoses are horrific on their own. But to have to go through this for 3 full years and having dozens upon dozens of documented procedures and treatments during the pendency of this case is something new that I am finding out. I did not know that. The defendants concocted a plan, executed that plan, and framed an innocent woman, and they are now responsible for these extraordinary damages Ms. Reed has suffered at their hands. Next section. Let's take a little break to just look at the chat for a moment. Lieutenant Pez Dispenser Tully has been here for 16 months and says, I love thinking of the Alberts, McCABEs, and Proctors, and Proctor squirming. What about Tully and Buchanan? Thanks for being here for so long. Timo says, is it normal for MSP to be embedded in a DA's office? Not where I'm from, not in New York. It's not. This is a weird thing that Massachusetts does. They assign police troopers to certain DA's offices, and so they have a relationship. They've been working together for many years. Remember, Lally's been working there since 2005. Proctor's been working there since 2012. So Lally and Proctor have been co-workers since 2012. No, that is not normal. Thanks for asking and for your super chat. Crystal says, if getting rid of the phones isn't a huge red flag for others, I don't know what is. I hope people look at this filing without blinders now. Whew. All in one place. And she also says, Crystal Ray says, I feel like this is Karen Reed's tell-all, finally, ever. Thank you for your super chats. Jackie's been here for 18 months. She says, thanks for going through this with us. It's my pleasure. I may run out of a voice because I hear there's also some other documents filed by Better Road today. So Jamie says, towing companies usually take pictures before and after free towing. Where are those pictures? Or did the towing company didn't take any? Well, the tow truck driver was on the witness list. He was never called. I do not know the answer to that question for sure, but I do know if any one of you who has ever called even AAA to come and tow your car, they will take 700 pictures from every angle because they don't want to be responsible for damage. So I don't know what happened because I don't have any inside information because that witness was never called. Lieutenant Pez Dispenser Tully, this is incredibly satisfying. Mel, you're heroic to read this rather than letting your malady get in the way. I needed this today. Feel better. Oh, thank you. Thank you. But wouldn't it be interesting if Proctor's phone and some of the pictures contained on Proctor's phone indicate a cracked tail light in the driveway at night? Because who wouldn't pull their camera out of their pocket if the tail light was indeed shattered and take a picture of it as an investigator? I mean, who wouldn't, right? Well, who knows what's in the extraction, but there could be something like that. Maybe, just spitballing with you. Thanks, MT, for becoming a member. The defense arrest says John O'Keefe's right hand has 2 needle marks. Tried to resuscitate him. Brushing around site means he was alive at the time. Thank you very much, defense arrest, for your 2 super chats from Australia. KLM says it's easy to click the X on live chat to close the chat and then hit the like button and come right back in. Thank you. Thanks for reminding everyone to do that and for offering $5 to let everyone know that. I appreciate you. Holly Johnson says, notice McCabe's and Albert's group is trying to include Turtle Boy into this lawsuit. I can't help, but they are banking on the division between Turtle Boy and Karen. It's so childish. I don't care who's wrong. It needs to stop. It needs to stop. Holly, it needs to stop. It needs to stop. yard. All right. Can you hear me now? Can you hear me now? Was it intentional? I don't know. Someone trying to sow division intentionally? I have no idea. I don't know. I'm going to try not to participate in any of that. Needs to stop. Thanks, Holly. Kay Willis is here. She's a realtor south of Boston. If you need to get out of Boston or south of Boston, Canton area, Norfolk County, and you want to sell your house, call Kay Willis. Or if you want to buy there, maybe you can get a good deal and she'll help you. Thanks for gifting 5. Next witness. Thanks for becoming a new member. We love your collabs. We love your, your mashups of all the attorneys and other YouTubers for all things reaction-wise to the many cases that we cover here on the Tubes of You. Okay, here we go. It's Mercury retrograde. That's what it is, yeah. MSP investigates and punishes Proctor, Buchanek, and Tully for their misconduct during the investigation. Proctor wrote more than 1/3 of the police reports in this case, testified at the state grand jury 3 separate times, interviewed every member of the Albert and McCABE families, had possession, at least until March 14th of 2022, of all of John O'Keefe's clothing and the taillight, all of the taillight pieces found broken from the housing, processed Mr. O'Keefe's Chevy Traverse the day after Miss Reed was arraigned, had access to and reviewed all the Ring videos, had access to and reviewed the surveillance from CF McCarthy's, had possession of all the Canton PD Sallyport and driveway videos and numerous other critical investigative activities. And yet, once evidence of Proctor's conflicts and lies became public, he was extricated from this case in an effort to hide him from the jury and sanitize the compromised investigation, while Ms. Reed was forced to trial not once, but twice. Ultimately, Michael Proctor was relieved from duty and transferred out of the detective unit of the Norfolk County District Attorney's Office on July 7th, 2024, mere days after the conclusion of Ms. Reed's first trial. Proctor was terminated from the MSP on March 19th, 2025. Upon a release from the district attorney of more implicating text messages from Proctor's phone, on October 18th of 2025, Proctor officially ended his appeal with the Civil Service Commission. On September 23rd, 2024, an MSP internal affairs investigation found YURY Bukhenik, quote, failed to perform his supervisory duties in an ongoing investigation. On July 7th, 2025, Bukhenik was transferred out of the Norfolk DA's office detective unit and reassigned to an administrative role in another division. Is he on desk duty since July 7th? On October 18th, 2024, Brian Tully was disciplined and reassigned from SPDU and stripped of his detective designation. Tully was given special dispensation by Norfolk County District Attorney Michael Morrissey to continue detective work on the Reed case despite his demotion because of his behavior on this case. You can't make this up. You just can't make this up. Upon information and belief, Troopers DeChico and Jeffrey Kikowski were also disciplined for their misconduct associated with the MSP's investigation of Ms. Reed. Well, I guess they don't have receipts on that, because when you say upon information and belief about something, it's just saying you have a reason to believe it, but you don't yet have the receipts on it, but you're going to find out in discovery, folks. Kikowski and DeChico also disciplined? Tell me more. If you were to write this as a pilot, let's say, and try and pitch it in Hollywood to a network, they would laugh you out of there. Be like, come on, nobody's going to believe this. It strains credulity. It's impossible. It's unrealistic. Nobody's going to believe it. It's about as unrealistic as Tulsa King has become. And they would laugh you out of there. But it's There's receipts on all of it. Section Roman 5 counts. Footnote 4 says, after making presentment pursuant to General Law 258, Ms. Reed will add counts against A, Massachusetts State Police for negligent training, supervision, and retention of MSP troopers, including Proctor, Buchanek, and Tully, and B, the town of Canton for negligent oversight of the investigation into Mr. O'Keefe's death and of its own officers and facilities. So they're like, yeah, we're gonna bring those later, but there are certain, as I explained earlier, procedural hoops that they need to jump through when you're suing, when they are suing a municipality. And so those things need to be done first, and then you can bring them in. Here are the counts. Count 1, 40 USC 1983. Malicious prosecution under the Fourth Amendment against Proctor, Buchanek, and Tully. This is the 1983 action that we've been waiting for. Proctor, Buchanek, and Tully violated Ms. Reed's Fourth Amendment rights by engaging in a malicious prosecution of Ms. Reed by causing her to be seized pursuant to legal process unsupported by probable cause. The criminal proceedings against Ms. Reed terminated in her favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. Proctor, Buchanek, and Tully caused Ms. Reed to be seized without probable cause, as described above, including, but not limited to, by leading, handling, and participating in the O'Keefe investigation, even though Proctor was conflicted due to personal relationships with various witnesses, suspects, and potential suspects, which conflict led to Ms. Reed's unlawful treatment. Handling the investigation, even though Proctor had an extreme and personal negative bias towards Karen Reed, which bias led to Ms. Reed's unlawful treatment. C, violating MSP's rules, policies, and procedures in all aspects of the investigation. Planting, fabricating, and manipulating evidence, falsifying documents, preparing false affidavits, and committing perjury. Failing to secure evidence and the crime scene. Obtain evidence, timely and appropriately interview suspects, and investigate Albert's, McCABE's, or Higgins, and allowing them to destroy potentially exculpatory evidence. Failing to consider and present exculpatory evidence to prosecutors and the grand jury investigating Mr. O'Keefe's death, such as the evident dog bite injuries on Mr. O'Keefe's arm, and evidence that his injuries were caused by an altercation and not a vehicle strike, such as the lack of lower body trauma. Following her indictment by a grand jury, Ms. Reed was rearrested without probable cause, forced to pay $100,000 bond to be released from custody, and required to comply with numerous pretrial release provisions. These post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. These deprivations continued during Ms. Reed's second trial, in part because of Proctor's false testimony at Ms. Reed's first trial. Among other things, Proctor falsely testified that, okay, I mean, a lot of facts in this complaint. This is very detailed, more detailed than you see most complaints. Incredibly detailed. Among other things, Proctor falsely testified that when he first saw the taillight of Ms. Reed's car at Ms. Reed's parent house in Dighton, it had large pieces missing, and the shattered taillight displayed at the first trial, as photographed on February 1st, 2022, was in the same condition as on January 29th. Remember, no photos of that taillight exist until they were taken by, I believe it was it Maureen Hartnett on February 1, same day as Karen's arrest, coincidentally. That's the first time photographs were ever taken of that taillight that we know of. He and Buchanek never touched any part of Ms. Reed's vehicle when it was stored in the Canton PD Sallyport. That's a lie. He retrieved taillight pieces on subsequent searches at the Albert's home when he knew he had deposited or arranged for someone to deposit taillight pieces at the property. Chris and Julie Albert were his loose acquaintances rather than friends. And his statements and sworn affidavits, all claiming the Lexus was seized at 5:30 p.m. and that he arrived in Dighton at 4:30 p.m. were typos. Thus, Proctor, Buchanan, and Tully, acting under color of law, violated Ms. Reed's Fourth Amendment rights against unreasonable searches and seizures. As a proximate result of this misconduct, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death and made to defend herself in 2 trials in the Superior Court for Norfolk County, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages for these harms, Ms. Reed is entitled to her attorney's fees under 42 U.S.C. 1988, costs, interest, and punitive damages. Count 2. 42, United States Code 1983, supervisor liability against Buchanan and Tully in their individual capacities. A supervisor is liable under 42 U.S.C. Section 1983 when the supervisor supervises, trains, or hires a subordinate with deliberate indifference toward the possibility that the subordinate's deficient performance will result in deprivation of an individual's constitutional rights. Buchanan and Tully knew or should have known that there was a grave risk that Proctor would fail to investigate the Alberts with whom he had a close personal relationship, which he had disclosed. They also knew or should have known that there was a grave risk Proctor would wrongly seek to have Ms. Reed charged, given the manifest bias evidenced in his text messages, which were sent to Buchanan, among others. Buchanan and Tully could have taken easily available steps to avoid a constitutionally deficient malicious prosecution of Ms. Reed. Those measures include, but are not limited to: 1, replacing Proctor with an unbiased investigator that had no personal relationship with anyone involved in Mr. O'Keefe's death. 2, safeguarding the crime scene and the physical evidence, including Mr. O'Keefe's clothing and 47 pieces of taillight material, to prevent anyone from planting, manufacturing, or manipulating evidence. 3, initiating timely searches at the Alberts' house. And 4, quickly seizing the cell phones and other forms of electronic evidence in the possession of the Alberts, the McCABEs, and Higgins, which would have prevented their later manipulation and destruction. See, they're setting forth all of the things that they could have or should have done, but what had happened was they just didn't. They just didn't. They just didn't care about investigating the murder of a fellow brother in blue, which is mind-blowing to me in and of itself. But from what we are learning about all of the other cases that we are continuing to cover in the Commonwealth, this just may be the way they've done it for decades. And they've never been caught or forced to suffer any ramifications until maybe now. By not taking any of those measures, Buchanan and Tully permitted Proctor, and Tully permitted Buchanan to violate Ms. Reed's Fourth Amendment rights against unreasonable searches and seizures, and thus themselves violated Ms. Reed's Fourth Amendment rights. In these ways and others, Buchanan's conduct constituted condonation of or acquiescence to Proctor's behavior or gross negligence amounting to deliberate indifference. In these ways and others, Tully's conduct constitute condonation of, meaning he's condoning it, or acquiescence to Buchanan's and Proctor's behavior or gross negligence amounting to deliberate indifference. So it was the same paragraph, but one was for Tully and one was for Buchanan. If it sounded repetitive, it's because it was. As a proximate result of their breaches, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages for these harms, Ms. Reed is entitled to her attorney's fees under 42 U.S.C. 1988, costs, interest, and punitive damages. Count 3, 42 United States Code 1983, conspiracy to deprive Ms. Reed of her Fourth Amendment rights against Proctor, Buchanan, Tully, the Alberts, the McCabes, and Higgins. All those people I just mentioned shared a common design and acted in concert to frame Ms. Reed for Mr. O'Keefe's death. As part of their concerted efforts and among their many other misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Ms. Reed made inculpatory statements on the morning of January 29th. When they made these statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Ms. Reed. Proctor, Buchanan, and Tully knew or should have known that the statements made to them by the House defendants were false and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Ms. Reed to the exclusion of everyone and anyone else. In furtherance of this plan, among other unlawful conduct, Proctor, Buchanan, and Tully agreed A, to continue to handle the investigation even though they had personal relationships with suspects in the murder, which led to unlawful and favorable treatment of potential suspects. B, to continue to handle the investigation even though they had biases against investigating the House defendants because of the House defendants' ties to law enforcement. C, to continue to handle the investigation even though they had exhibited an extreme and personal negative bias toward Karen Reed. And D, to violate rules, policies, and procedures in all aspects of the investigation. Oh, there's more. But wait, there's more. E, to plant, manufacture, and manipulate evidence, falsify documents, and commit perjury. F, to not secure evidence and the crime scene. G, to not investigate and obtain available evidence or timely and appropriately interview suspects. And H, to not investigate the McCabes, Alberts, or Higgins. The McCabes and Alberts, okay, so that was all of the allegations with regard to the conspiracy among law enforcement. And now the McCabes and Alberts coordinated their efforts through text messages, phone calls, and conversations. Higgins and Brian Albert coordinated their efforts through telephone calls and texts on their phones, which were later destroyed or discarded. Finally, Proctor, Buchanan, and Tully coordinated with the Alberts and McCabes through Proctor's sister, Courtney, who communicated frequently with Julie Albert. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCabes and Brian Albert in a cursory manner, and all at the same location, midday on January 29th, and Nicole Albert on February 3rd. Remember, they said they interviewed the McCabes and Brian Albert at the McCabes' house. Proctor and Buchanan only interviewed Higgins once at his attorney's home and did not secure or search his phone or search for communications between him, the Alberts, and the McCabes. I mean, if Higgins does that evidence consciousness of guilty that Higgins would insist on being interviewed at his attorney's office? And remember, he went to the FBI kiosk to visit his friend Matt Kelch, who taught him how to use that machine in the FBI, and let him use the machine to extract or cherry pick certain messages, text messages between himself and Karen Reed and himself and John O'Keefe. And he brought those printed up with him to his interview, to his attorney's house. Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and the cover-up. As a result of the conspiracy between and among them, Proctor, Buchanan, and Tully never investigated the House defendants, and instead, Ms. Reed was wrongfully arrested and prosecuted in violation of her Fourth Amendment rights. Get Kelch on the stand, says Nicola. All because they never thought Karen could or would fight, says Teresa. Yep. Proctor, Buchanan, Tully, and the House defendants acted in unison and had a peculiar power of coercion over Ms. Reed because Proctor, Buchanan, and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Ms. Reed because of their personal and professional connections to Proctor, Buchanan, and Tully, and their superior knowledge of police and criminal investigations as a result of their own work in and connection to law enforcement. The proximate result of Ms. Reed's wrongful prosecution was her loss of employment, reputational damages, millions of dollars of legal expenses, and serious emotional and physical distress and injury. In addition to an award of damages for these harms, Ms. Reed is entitled to her attorney's fees under the same statute. Count 4, Massachusetts Civil Rights Act, MCRA, against Proctor, Buchanan, Tully, Alberts, McCabe's, and Higgins. So the 1983 claims are federal claims. Massachusetts also has a Civil Rights Act that allows similar causes of action in state court. And this has been filed in state court. This is not in federal court, but it's been filed in Bristol County. Proctor, Buchanan, Tully, and the House defendants interfered or attempted to interfere with Ms. Reed's exercise or enjoyment of her rights under the federal and Commonwealth constitutions and laws through threats, intimidation, or coercion. Among other acts, by manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins phones, and ignoring exculpatory evidence such as the dog bite injuries and a lack of injuries consistent with a vehicle strike, Proctor and Buchanan caused Ms. Reed's wrongful indictment, arrest, and prosecution, and thereby interfered and attempted to interfere with her rights under the Fourth Amendment to the U.S. Constitution and Article 14 of the Massachusetts Declaration of Rights. By falsely representing that Mr. O'Keefe never entered the Albert house, and by relocating his body to the location on the Alberts property where they would claim Ms. Reed dropped off Mr. O'Keefe, the Alberts, the McCabes, and Higgins caused Ms. Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Ms. Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. The House defendants thereby interfered and attempted to interfere with Ms. Reed's rights under the Fourth Amendment to the U.S. Constitution and Article 14 of the Massachusetts Declaration of Rights. Ms. Reed's wrongful indictment, arrest, and prosecution were intrinsically coercive under Massachusetts law. Moreover, the House defendants and Proctor, Buchanan's, and Tully's conduct amounted to threats, intimidation, and coercion designed to force Ms. Reed to give up her defense and plead guilty to a crime she did not commit. Remember, if she takes the plea, it'll all be over. If not, it's going to be a whole other episode. As a proximate result of defendants' actions, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damage, and millions of dollars in legal expenses, as well as serious emotional distress and injury. Plus, she is also entitled to attorney's fees. Count 5, common law malicious prosecution against Proctor, Buchanan, Tully, the Alberts, the McCabes, and Higgins. So not only are they alleging statutory violations, they're also common law is case law. Some of you may consider it case law, common law. There's a major outage and it's affecting a lot of things. Yeah, I know I'm muted. I'm not muted now, right? Okay, I'm back. I'm back. Common law malicious prosecution. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins phones, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor, Buchanan, and Tully caused Ms. Reed's indictment, arrest, and prosecution. Ms. Reed's indictment, arrest, and prosecution occurred without probable cause because they were based on false, manufactured, manipulated, and planted evidence, and because Proctor, Buchanan, and Tully ignored exculpatory evidence and allowed potentially exculpatory evidence to be destroyed. And yes, it does sound repetitive, so I think we know what they're getting at. Wrongful arrest, wrongful prosecution, malicious prosecution, destroying evidence, conspiring to do all of these things, conspiring to pin it on the girl, destroying, planting, manufacturing evidence, all in violation of Karen Reed's civil rights. These criminal proceedings were instituted with malice, as evidenced by Proctor's, Buchanan's, and Tully's knowledge that it was based on false evidence, Proctor's, Buchanan's, and Tully's bias and ill will toward Ms. Reed, and for the improper purpose to protect Proctor's friends and acquaintances, the Alberts. The criminal proceedings terminated in Ms. Reed's favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. By falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location on the Albert property where Jennifer McCabe would claim Ms. Reed dropped off Mr. O'Keefe, Brian and Nicole Albert, the McCabes and Higgins, caused Ms. Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Ms. Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. As a proximate result of defendant's actions, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional distress and injury. Count 6, intentional infliction of emotional distress against Proctor, Buchanan, Tully, Alberts, McCabes, and Higgins. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home, or the Alberts and Higgins phones, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and the lack of injuries consistent with a vehicle strike, Proctor, Buchanan, and Tully caused Ms. Reed's indictment, arrest, and prosecution. By falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location on the Albert property where Jennifer McCabe claimed Ms. Reed dropped Mr. O'Keefe, the Alberts, the McCabes, and Higgins caused Ms. Reed's wrongful indictment, arrest, and prosecution of Ms. Reed. Brian Albert and Brian Higgins also caused Ms. Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. The defendants knew or should have known that their conduct would cause Ms. Reed emotional distress since it would lead to her prosecution for murder and other crimes. And the conduct did cause and is causing Ms. Reed severe emotional and physical distress. The defendant's conduct perverted the justice system, allowed Mr. O'Keefe's true killer to escape liability, and threatened to imprison Ms. Reed. It is the type of behavior that threatens civilized society and is therefore extreme and outrageous. As a proximate result of defendant's actions, Ms. Reed suffered emotional and physical distress and injury. Count 7, civil conspiracy against all of the defendants. And if you're just tuning in, these are all the defendants that are sued in this lawsuit: Proctor, Buchanan, Tully, Brian and Nicole Albert, Jennifer and Matt McCabe, and Brian Higgins. And we are on paragraph 162, count 7, page, 42. Proctor, Buchanan, all those people I just mentioned shared a common design and acted in concert to frame Ms. Reed for Mr. O'Keefe's death. That's what you need to show a civil conspiracy, that all of these people acted together to frame her or to do something. In this case, to frame her for Mr. O'Keefe's death. As part of their concerted efforts, and among their many other misrepresentations, Alberts, McCabe's, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that that they did not see Mr. O'Keefe in the house that night, and that Ms. Reed made inculpatory statements on the morning of January 29th. When they made these statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Ms. Reed. Proctor, Buchanan, and Tully knew or should have known that the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties, I don't know, we're breaking the internet or something. There's still over 12,000 of you here. Smash the like button, get it out. We're breaking the internet. She's telling us everything. And we're reading it all because we ain't got no quit. I'm not muted right now. You must be behind. If you're behind, then I'm muted. If you're on real time, I'm not muted. It is a party in here. What a day. Whew. Brian Walsh pleading guilty to 2 of his charges. Everybody getting served in this case. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for and implicit direction to conduct an investigation that solely targeted Ms. Reed to the exclusion of everyone and anyone else. In furtherance of the conspiracy, Proctor, Tully, and Buchanan agreed to fabricate, plant, and manipulate evidence purporting to show that Ms. Reed's vehicle hit Mr. O'Keefe. Pursuant to their plan, Proctor, Buchanan, and Tully carried out multiple overt acts, including damaging the taillight on Ms. Reed's vehicle while it was in the town of Canton Sallyport, not securing the crime scene, and depositing taillight pieces on January 29th, prior to the MSP CERT team's arrival on site. Depositing taillight pieces. I might have said sprinkled, but that's just. In addition, Proctor deposited some of the broken taillight pieces on Mr. O'Keefe's clothing while the clothing was in his unprotected custody. Proctor also deposited some of the broken taillight pieces on Mr. O'Keefe's clothing while the clothing was in his unprotected custody. Proctor also deposited glass alleged to have been from a cocktail glass on the bumper of Ms. Reed's Lexus SUV sometime prior to the vehicle's processing by MSP Crime Lab on February 1st of 2022. Another part of the conspiracy was to take coordinated steps to ignore and destroy potentially exculpatory evidence that pointed to other suspects like Albert and Higgins, like the Alberts and Higgins. The McCABEs, the Alberts, and Higgins coordinated through text messages, phone calls, and on information and belief conversations. Higgins and Brian Albert coordinated through telephone calls and on information and belief texts on their phones, which were later destroyed or discarded. Finally, Proctor coordinated with the Alberts and McCABEs through his sister Courtney, who spoke frequently with Julie Albert. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCABEs and Brian Albert in a cursory manner on the morning of January 29th and Nicole Albert on February 3rd. All told the same false story that Mr. O'Keefe never entered the Alberts' house. Proctor, Buchanan, and Tully also only interviewed Higgins once with his attorney at his attorney's home and did not secure or search Higgins' phone or search for communications between him, the Alberts, and the McCABEs. Pursuant to the coordinated plan, Proctor, Buchanan, and Tully also did not search the Alberts' phones or home where there was likely evidence of O'Keefe's murder. Further, Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. Following Mr. O'Keefe's death, among other acts, the McCABEs and Alberts agreed to make it look like Mr. O'Keefe died due to exposure after being hit by Ms. Reed's car. As part of this common plan, Brian, Albert, and Higgins, both law enforcement officers familiar with investigations, communicated at 2:22 a.m. on January 29th after Higgins left the house. Today feels like the Super Bowl. What is happening? So today feels like the Super Bowl. Yes, excellent point. Proctor's psychological evaluation. Imagine what else will come out from not just his text messages, but the total extraction of Proctor's phone. And it is important to note that they can amend this at any time, depend on if and when they get Proctor's total phone extraction. They can certainly add more facts and amend their complaint. So stay tuned for that. Shortly thereafter, as part of the plan, Jennifer McCABE deleted a Google search at 2:27 a.m. on January 29th for how long it takes a person to die in the cold. One or more of them relocated Mr. O'Keefe's body and deposited it in front of the Alberts' house, where Jennifer McCABE claimed that Ms. Reed had dropped Mr. O'Keefe off earlier. The McCabes and Alberts then coordinated what they would say to police, all of them falsely telling investigators that Mr. O'Keefe never entered the house. Proctor, Buchanan, Tully, and the House defendants acted in unison and had a peculiar power of coercion over Ms. Reed because Proctor, Buchanan, and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Ms. Reed because of their personal and professional connections to Proctor, Buchanan, and Tully and their superior knowledge of police and criminal investigations as a result of their own work in and in connection to law enforcement. Proctor's, Buchanan's, Tully's, and the House defendants' conduct described herein were unlawful and tortious. I've seen this word pronounced many ways. It is tortious, Tortious, meaning of a tort, and not the kind of tort that you eat. Tort is a form of negligence. I know, I was muted because something's going on here in the world. Tortious, in case you're confused about how to pronounce it. Among other things, they constitute intentional infliction of emotional distress, negligence, common law, malicious prosecution, and violations of Ms. Reed's rights pursuant to the U.S. Constitution and the Massachusetts Declaration of Rights. As a proximate result of defendants' actions, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. Jury demand. Ms. Reed respectfully requests a jury trial on all matters so triable. Prayer for relief. This is just basically what you're asking for. Where it has nothing to do with religion. I'm getting punchy. I've been reading for a really long time. Wherefore, Ms. Reed respectfully requests that the court grant her the following relief. Enter judgment in her favor and against each relevant defendant on each count of this complaint. Award her damages in an amount to be calculated at trial along with pre- and post-judgment interest, costs, and expenses. Award her reasonable attorney's fees incurred in connection with this litigation. Grant her such other relief as the court deems equitable and just. XOXO! Karen Reed by her attorneys, Sheehan, Finney, Bass, and Green, Damon Seligson, and a few other attorneys, and also Alan Jackson, pro hoc vice, and Elizabeth Little, pro hoc vice, Caleb Mason, pro hoc vice, for the Worksman Jackson firm in Los Angeles, California. Dated yesterday, November 17th, 2025. And it hit the docket today. And boy, that was a read, huh? That was a read. Oh, excuse the pun. 46 pages of everything that we've been waiting for in the civil rights action. I've been predicting since, I don't know, day 1 or 2 or 3 or 4. How long have I been screaming about this? Long time. Long time. I don't even know if I can summarize this for you. This is a civil rights case. There are 7 or 8 causes of action, including civil conspiracy, violation of federal law, violation of Karen Reed's civil rights, including her Fourth Amendment rights, wrongful prosecution, malicious prosecution, coercion, conspiracy to commit these crimes, to frame the girl, to pin it on the girl, failing to do a proper investigation. We've been waiting a long time for this, and it did not disappoint. Intentional infliction of emotional distress, civil conspiracy, and all the things, and all the people who were sued in this lawsuit, and for those who remain to be sued, the Massachusetts State Police and the Canton, I think it's Canton PD. Wait. All right, so here's who's named: Proctor, Buchanek, and Tully, all personally, to get around qualified immunity. Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. The following defendants will be added after procedural hoops are jumped through: the Massachusetts State Police and the town of Canton. And Janai said, wow, that was almost as satisfying as the mega motion. Right? All right. I'm going to take a minute to look at your thoughts, questions, comments, and concerns, because that was a lot. Thank you, Stephanie, for your $50 Venmo. Says, thanks for reading the papers. The papers. Friend of dog. Thank you so very much for your very generous Venmo. You guys are so generous. And Kelly, also for your $50 Venmo to my favorite YouTube channel. I love you with all my heart. I love you more. You guys are so generous to me. I love you so much. Thank you, Lindsay, for your Venmo. If Karen was parked head in at her parents', wouldn't Barros's dash cam have possibly caught her taillight? Yes, but he didn't have any. He didn't have any, is my understanding. Sorry if I missed this. Was driving my 18-wheeler full of scaffolding. Thanks for making my workday better. Thank you, Lindsay, for listening and watching. Dighton doesn't have dash cams, is what I understand. And so neither did Tom Ferry's vehicle. And he plowed the driveway for the Dighton. He's the superintendent of highways for Dighton. Danielle, thank you. Says, best taste ever. Doesn't taste great, but works incredibly with honey. Honey, try it on me and feel better. Oh, thank you. Is it throat coat? Because I do drink throat coat. I just don't have any right now. I usually just eat spoonfuls of Manuka honey and it helps. And I hate vocal fry. Like, it makes me crazy. So I hate it. And I know that you hate it too. Not you particularly, Danielle, but others hate it. And so that's what I do. Oops. Robin, thanks for a matcha latte. Thank you so much. Oh, forgive you for what? You didn't do anything wrong. Thanks for your matcha latte. I'm going to need it. And Better filed something, but I don't think I can do that right now. I think I got to take a rest for a little while. I think tomorrow will be a good day to go over all that stuff. Goodmans are here for 14 months, and they say wouldn't want to be anywhere but here for this. Oh, we love you guys. We love you so much. Elf, thanks for 22 months of membership. Says, listening while working. Thanks, Mel. Thank you, Elf, for being here for so long. Toasty Bun says, Jen won't find a cross necklace big enough to make her look innocent. Well, it's going to cost them some money in attorney's fees for this one. Thank you, Toasty Buns. Donnie says the time and work it must have taken to create this. Yes, that's why it took a while. It took a while, but it's hot off the press. And we covered it. Pickle juice. Oh, is that what it's good for also for your throat and voice? I haven't, but I do have some pickles in the fridge. So I will go drink some pickle juice and see if it works. Cool. Thank you, Betsy, who says doing the Lord's work again. Thank you for your another 10. I love when people are on replay and they write in the comments, you're muted. I'm like, you're on replay. We figured it out. No worries. We got it. I love Labrador says, you're the best, Melanie. Thank you for being with me for 7 months. You're the best. Inverted Sneaker says, how would you advise the McAlberts if you were the attorney? That's a great question. I'd have to think about that because I am a plaintiff's lawyer, not a defense attorney by trade. But listen, their attorneys are going to be billing by the hour. And so, the more hours, the better. And nobody's taking this on contingency. They need defense attorneys to defend them in this. And they're going to need different ones too. They're not going to all be able to have the same attorney because everybody's interests are different. It's interesting. It's an interesting thought. I'm going to have to think about it because I don't want to help anybody. You know what I'm saying? I don't want to help anybody. So I'm going to keep that to myself for now. Gen X Jen, thanks for being here for 5 months. Collision, no collision, no collision, no collusion. Yes, thank you, Melanie. You rock. Thank you for being here for 5 months. Helena says, the more times I hear the story, the crazier it gets. Feeling so excited. The papers spilling all the beans. I love you. I love it with all of my heart. Thank you for tuning in from Sweden. Kelly says, Kelly changed her name to Kelly. The downfall of McCanton's posse begins. Can see it from across the pond. The first time seeing all the wrongdoings in one place, I knew it was bad, but wow, this is awful. Karen is a woman of steel. She is. She is. And if you have friends that don't know anything about this case, just direct them to this stream because it tells you everything you need to know in this complaint. It's all there. Everything that happened to Karen Reed and all the wrongs that were done to and upon her are there. It's a good summary of the case and the violation of her civil rights. Hold on. Thank you for your super chat, Kelly. And on top says the one-way tickets to Vietnam just sold out. Well done. Well done. You guys are the snark tank for a reason. Thanks on top. And Gigi says it would never happen in the state of Texas. Thanks, Gigi. Weekend Up Evie says, remember we had a verdict, then we didn't have a verdict and it was sealed. Could it ever come out through any of this? I love you with all my heart. I remember that there was an envelope and then someone changed their mind, and no, that probably would never see the light of day. And honestly, I can't remember all of the details of it. And I don't remember if any of the jurors spoke out about it. And so, no, I don't think that would ever see the light of day. But I think that the sidebars should and will and have to, because they're part of the public trial record. The public has a right to know. Beth Ellen, thanks for being here for 6 months. Sometimes the process is the punishment. Well done. Ms. Lily says, you're the best. Wouldn't the union provide 4 months? What do you mean? The union is not going to represent them in this lawsuit again. I don't know what you mean. Wouldn't the union provide 4 months? I have no idea what you mean by that, Ms. Lily. I'm sorry. I just don't know what you mean. It appears that, and we did mention this earlier in the stream, that federal prosecutor Adam Deitch has declared his run for the Norfolk County District Attorney. So that's interesting. He just announced that today, hot off the press. Let's take a look at that because, you know, we ain't got no quit, and I'll just keep talking until my voice is just totally gone. Let's see. Hold on. I mean, good things are happening here. Listen, in my opinion, the people that were running for Norfolk DA that have announced their run have not been taking advantage of all of the things they could be talking about. It's crazy. Like they should have been out here screaming into the ether about all of the things that Michael Marcy should and could be doing or should have done and hasn't done. And it could have been out here screaming, I'm going to investigate the murder of John O'Keefe. I'm going to do all the things that Marcy didn't do. And here it is. Federal prosecutor Adam Deitch declares his run for the Norfolk County DA. This just WCVB broke this a little while ago. Oops. There he is. Hold on. A former assistant U.S. attorney who had a leading role in the federal investigation into the handling of the Karen Reed case announced Tuesday that he is running for Norfolk County District Attorney. Adam Deitch of Quincy left his position as an assistant U.S. attorney for Massachusetts on November 7th to launch his challenge to current DA Michael Marcy. I left my job as a federal prosecutor because it's clear there's a problem in Norfolk County. Victims are not getting the justice they deserve. The public has lost faith in the system. And someone has to do something about it, he said in a written announcement about his campaign. In his announcement, he touted his success as a federal prosecutor handling corruption cases across the state, including a Massachusetts State Police CDL bribery scandal, driving license fraud and bribes, and a fraud case involving Boston community activist Monica Cannon Grant. Deitch also served as a lead assistant U.S. attorney in the federal investigation into the death of Boston police officer John O'Keefe and the state investigation and prosecution of Reed. Well, he just told us what the feds were investigating. We weren't sure what they were investigating, but he's telling us everything, and he just told us what they investigated. The federal investigation into the death of Boston police officer John O'Keefe and the state investigation and prosecution of Reed. Right? Marcy has been largely absent from the pub, but you know what? Mainstream media often gets it wrong. So, like, I don't even know that I want to even pass that along because that might not even be what he said. Right? Marcy has been largely absent from the public eye since June when Reed was found not guilty of the two more serious charges brought against her in her retrial in the death of John O'Keefe. Marcy has been the district attorney since 2010. And this is repetitive, and it's just the same thing over and over again. What do you think about that? Adam Deitch, anybody familiar with him? Anybody know anything about him? It's an exciting candidate. I agree. It's an exciting candidate. Oh. Ms. Lily C says, sorry, wouldn't the union provide attorneys for Tully and YURY? No, I don't think so, because this is a civil lawsuit, and they're sued in their personal capacity, not in their capacity as law enforcement officers. So I don't think so. I mean, if anybody lives in Massachusetts and you're familiar with the union and you think that they would offer them attorneys, I don't think so. Or in-house counsel of some sort. It's a good question that I don't exactly know the answer to. I lean toward no, but I don't know for sure. If anybody knows, let me know. Yeah, Mass Dad says, nope, unions wouldn't help. I didn't think so. They're being sued in their personal capacity to get around qualified immunity. And so therefore, they're going to have to come out of pocket on this. And listen, and I've been saying this also, I've been screaming this into my microphone since the beginning. You better want what you wish for to the O'Keefes. And listen, I sympathize with them greatly. I really do. Nobody should ever lose two children. And that is very tragic. And the children have lost two sets of parents, right? If you're going to sue Karen Reed for this, you will have to assume that she is going to third party in all of the people who are at the house who may be now your friends. And so in suing Karen Reed, when there was no evidence of a car accident, you are putting your friends potentially in harm's way, and it's going to cost them a lot of money to defend themselves. And she likely would have filed this lawsuit whether or not she was sued for wrongful death. I don't think this is retaliatory at all, because she absolutely, her vile rights, her civil rights were violated. Absolutely. Her civil rights were violated, in my opinion. It's pretty easy. All the facts are set forth, very detailed in this complaint. And she would have filed it anyway. But when you sue somebody for wrongful death, you have to assume that if they don't feel that they're responsible, they're going to third party in the people who are. That should have been predictable on the plaintiff's attorney's part. So when the plaintiff's attorney in the O'Keefe versus Reed matter was shocked in court, by the way, there's another hearing on Friday afternoon. We're going to cover that live in this civil case that's pending in Plymouth County. They're probably going to discuss this. When the plaintiff's attorney was shocked that Karen Reed's attorney said, yeah, we plan on bringing in 10 new parties, I think he's the only one on the face of the planet that was shocked by that, because I saw it coming. And you saw it coming. And we all saw it coming. Which reminds me of my favorite musical, Chicago. He had it coming. He had it coming. He had it coming all along. Thank you for your super chat, Ms. Lily. And Sue Mo says, now we know what Jim might have been mulling over during the Walsh's plea hearing in court today. If you know, you know. Yes, he was looking at the ceiling. We're like, what is Jim? Why is Jim looking at the ceiling? Why is Jim looking at the ceiling? What's he looking at? Brian Walsh is pleading guilty to 2 charges. What has got his attention? Maybe this was it. Thank you, Anne, for your Venmo. This is great coverage. Thank you. Thank you guys so much. Venmo is a great way to support the channel because YouTube takes takes 30% of super chats. And if you super chat from your iPhone, the YouTube apps, the App Store on Apple takes 30% of that super chat before it even goes to YouTube, and then they take another 30. So Venmo is always a great option, and I'll still read your questions. And Elizabeth paid. Elizabeth sent Venmo, and she said, "Thank you for all that you do. Thank you guys for being interested in this and for suffering through my vocal fry today." And Kathleen says, "Appreciate your insight today on the civil case. Looking forward to your continuing coverage on this." Oh yeah, we're here forever. We're here for all of it. Jim was reminiscent. Jim was thinking back, looking at the fans. He was out there missing the fan. There's so many other things to cover, and so therefore we will have so many other things to talk about tomorrow. I just want to make sure that I didn't forget to I'm sorry to everyone who had to go to work today, because you guys probably got nothing done. You can tell your boss, you can blame it on me if you want. Just make sure your boss goes into my stream and gives it a thumbs up. I take full responsibility for your employees not getting anything done today. I heard somebody in the morning stream during Brian Wallace saying, I'm canceling all my meetings for this afternoon if you're going to read Karen Reed's papers. And we sure did. Is there anything that's stood out to you as being shocking? Anything that stood out to you as being new information that we did not know? Any questions that you have before we wrap this? Because you guys have been an amazing audience today for very many hours between this show and the last one. And you're absolutely right. Thank you, Sue, for your super chat. And we still have over 10,000 people here, so smash the like button. So nice of you. I tell my boss that Melanie Little is my boss. Justice for Teresa says, Karen Reed and her attorneys are seeking the truth. The depositions will be everything and go on for days. The truth will come out. The sunshine is coming. It'll be rising over the can ice cream truck. So true. Civil discovery rules are so broad. You can depose whoever you want, pretty much. All objections are preserved for the time of trial, and you can depose someone for days. For days. Federal court. Does it go to federal court? Well, they filed it in state court. They've got the option to file it in state or federal court. State court has jurisdiction. They did say in the papers that they're going to look to consolidate this lawsuit with the O'Keefe versus Reed lawsuit. Problem is, they're in different counties. Karen filed this one in Bristol County because that's the county of her residence, and Paul O'Keefe filed in Plymouth County. But here's the thing, and I just thought of, Karen doesn't have jurisdiction in Plymouth County because none of the defendants reside in Plymouth County, and she doesn't reside in Plymouth County. And so therefore, she does not have a jurisdictional basis to bring it in Plymouth County. She brought it in Bristol, which is where she lives. So there's that. Nope, they did not sue Colin. She did not sue Colin because the allegations here are conspiracy and the framing and the deflecting. She's not accusing them of actually having killed John O'Keefe. She's accusing them, or she's not really. The allegations are in this civil lawsuit that they violated her civil rights. And so Colin Albert is not involved in that. As far as she's concerned. That is true. Private investigators make serious money in civil litigation as well. Thankfully, Karen does all the work from her PI from her criminal cases, right? And she's got ARCA's reports. All the work is done. All the work is done. She's got ARCA's reports. She's got amazing witnesses. Irene Scorti-Bello has already testified. She's got, the best witness, my favorite witness, was the brain doctor. The brain doctor. Why is her name totally escaping me right now? Who examined John O'Keefe's brain in a jar. She told them everything. She told us everything about all the brain injuries and how they were caused. Dr. Help me. Stonebridge. Thank you. Renee Stonebridge. Dr. Renee Stonebridge. Also employed by the state of Massachusetts in the medical examiner's office. She was amazing. The beautiful woman with the full sleeve tattoos. Right. Renee Stonebridge. She's got all the answers. They've got Dr. La Posada. They've got the Crash Daddies. They've got everyone. And the 227 search is not a huge part of this case. I mean, it is a part of it. It's not a huge part. It goes to Jennifer McCabe's part in the conspiracy. So there's that. Renee Stonebridge. She only testified in trial number 1. Dr. Russell. Yep, Dr. Russell. Dr. LaPosada. Garrett Wing could come in and testify during this trial about dog bites. So there's that. They did mention the dog bites. Yeah, it was in the beginning. And during most of the beginning pages, maybe the first, I don't know how many pages, 20 pages, were all just facts. Facts. Nems girl says, I'd give her $500 million after taxes and court fees. Michael Easter could come in and testify. Yes, he would be an excellent addition as an expert witness to talk about how the investigation should have gone, what they should have done. Right? They're lucky. Yep, Garrett Wing, Michael Easter, and so it's going to be amazing. We'll cover it. I'm sure it'll be televised because Law and Crime and Court TV know where their ratings are. They know where their ratings are, and their ratings are with Karen Reed and all of her cases because people want to watch, and the world is interested, and the world is watching. You guys are here, and Kippy Hippie says, Melanie, you make me work harder. Thank you. Thank you. All right. I'll take credit for that too. Tell your boss that. I hope you sold a lot of stuff today or whatever you do. And thank you to someone who bought a matcha latte. It just came up as someone. It didn't come up with your name. Whoever that is, I give you credit. Thank you very much. And Kimmy, thank you, says, thank God, because people with power here in Bristol County are still outraged. Thank you, Kimmy, for your Venmo. You guys are the greatest. There's a lot of more stuff to cover tomorrow, but I'll have to do that after I rest my voice, including Aiden's filing, which I'm just being sent, and it is something like 26 pages. Guys, I just don't have it in my voice, but I promise you we will cover it tomorrow morning. Let's say 10 a.m. Okay. All right. Thanks to the moderators who are amazing at what they do. This is the hardest working mod team on the tubes of you, in my opinion. And they are amazing. And I could not do this without them. They are fearless and they're amazing. And my viewers, you are amazing. And to everyone on replay, you're amazing too. Just smash the like button, share the stream out, do all the things. I'm sorry that I'm not feeling well today, but hopefully I'm going to be able to rest and do this again with you tomorrow. Peace. My friends, stay cool, stay kind, stay classy. I don't know. You know what to do. You know what to do. I don't need to tell you to know what to do because you just do it. Well, somebody says, I love how they waited for the McAlberts to say they might sue and then drop this. No. This was filed yesterday. The McCabe and Albert statement was in response to being served with this. So don't be confused about that either. Don't be confused. This just hit the docket today. So we got a copy of it today, but they've already been served. And so that was in response to that. And we'll see what they file next. They haven't answered, so we'll see. All right, stay cool, stay kind, stay classy, do all the things. Be nice to each other. Keep doing the Lord's work. Come into the rabbit holes with me. We got a lot more things to cover, including the Brian Walsh trial that is going to start December 1st. They started to pick the jury today. And if you didn't watch my morning stream, Brian Walsh pled guilty to 2 of the counts against him. He pled guilty to disposing of a body, and he pled guilty to misleading a police investigation. Okay? So none of the jury's not going to hear about any of that stuff, but he's still going to go to trial on the murder charge for Anna Walsh. But he is admitting that Anna Walsh is dead, which is something a lot of people didn't believe. And so it's going to be fascinating. You need to watch that too. Go back and watch that too. It's such a wild day. It's like Christmas. Love you guys. Take care. Thank you. Thank you, Boston Wild. Peace out, guys.